DJ Cypher Lee in the mix.
Drown out the noise. Listen to the sound of my voice. And just take a second to refuel. 'Cause when you stop worrying about other people, life is kinda peaceful. So come, go through the motions with me. I want you to breathe in and hold it for free. Breathe in. And breathe out. Let go and release. This is your moment of peace.
Turn up the speakers. It's DJ Cypher Lee in the mix.
morning. We are ready to start this second day of this wonderful program. Thank you for settling in. We welcome you to this second day. Honorable Chief Justices Emeritus, Justices of Apex Courts in Africa, distinguished judges, heads of organizations, the Secretary General and staff of AJJF, delegates, ladies and gentlemen. Dispatches from Africa have reported that Nairobi is on fire. But Nairobi is on fire because judiciaries and heads of judiciaries have come together to assert critical core democratic principles and reaffirm the place of the judiciary in governance and in the prosperity and peace of our countries. So, congratulations to you all. The continent knows that something is happening in Nairobi. Welcome to this second day of the All Africa Judges and Jurists Summit. Yesterday, we had excellent discussions on judicial independence, on electoral justice in Africa, and on protection of the civic space in Africa. Today, we extend these conversations to access to justice. We will also specifically talk about access to justice for victims of historical crimes. As we advance into the fourth industrial revolution, we will consider what changes technology has on the law and human rights, and what the place and future of artificial intelligence in the dispensation of justice means for justice delivery. We also have a special program today at noon where we delve into judicial financial independence. Let me just get that right. You have the program of the book launch of a publication on financial independence in judiciaries in Africa on your desk. So today we are working backwards because we have to end at 11:20. Forgive me if we are a bit strict on time today, but it is because we want to give today's program the great prominence that it deserves. If you look at your program, we have session 4 to start us off, and then we will take a break at 11:20 and come back to the room at 12 o'clock for the launch of the book by Konrad Adenauer Stiftung. You have the program on your desk, so when we break at 11:20, I welcome you all back to the room at noon for that launch. I will incentivize you because there will be a free book to take away and excellent discussions within it. We will then come back after lunch to talk about law, human rights, and technology, and then we will have a session on the summit communique from 4:15 a.m. Without much ado, let me welcome Commissioner Duncan Okello to give us the introductory remarks for the session on access to justice. Karibu.
Good morning, everyone. Good morning. Yes, that's much better. Thank you very much, the Director of Programs for today, Rose Washuka, who is the Chief of Staff to the Chief Justice of the Republic of Kenya and President of the Supreme Court. I just have 2 introductory comments to make. The first one is with respect to the theme of the conference. The theme of our conference is Pivoting Judiciaries for the Transformation of Africa into the Global Powerhouse of the Future. I think about 20 years or 25 years ago, it would be very difficult to have judges addressing something like this. It speaks, I think, to the evolution that we've made in Africa in trying to reposition our country's judiciaries as part of our constitutional and democratic evolution. And when I reflected on this theme, I went back to the book that Justice Lenaola talked about, of the former Chief Justice Willie Mutunga. On page 310 of that book, Chief Justice did make a speech, or deliver a speech in Malawi, CJ, to the Malawian Bar Association. And the title of that speech was on Africa's electoral condition, judiciary as a political actor. And just one paragraph that speaks to this theme, I think, is important. So he says, in conclusion, if the political class, political parties, the bureaucratic elite, the military, the church, and even international capital have had their say in decisively but ruinously shaping Africans' governance and development trajectory in the years past, it would appear that the natural evolution of African constitutional and political order has created this historical moment for the judiciary to have its turn and say in determining Africa's democratic path. It is an opportunity for the judiciary acting as an agent for social transformation to fortify Africa's democracy, rule of law, and accountability, and to markedly improve on the governance record of other state institutions and actors that have sometimes unconstitutionally intervened in electoral processes. The judiciary has a historical obligation to acquit itself well and earn public respect as the last frontier or custodian of Africa's democratic development. It is the judiciary tirist with Africa's democratic and developmental destiny. That paragraph just reiterates the ambitious nature of the judiciary in Africa in the first half of the 21st century. Now, which brings me back to the theme that we are discussing today, access to justice. And the first session is going to look at historical injustices. And when you look at Africa history, we are a very wounded population. We were wounded by slave trade. We were wounded by colonialism. We were wounded by the Cold War. And we are continuously wounded by the new neoliberal international order. If you look at those 4 epochs in human civilization, Africa is wounded. Injustices have been perpetrated, both exogenous and endogenous. The question is, how can we provide frameworks for accessing justice for those that have been victims of historical crimes? What mechanisms exist, and are they effective in providing remedies for those crimes? To help us answer those questions, we have a panel with the lead presentation being Brian Kegoro, followed by 4 discussants that are in our midst: Dr. Catherine Namukula, Mr. William Kariu, Advocate Waiko Wanyoike, and Ms. Henrietta Kefre. We shall begin by listening to Mr. Brian Kagoro, who will make his presentation via video recording. And then we shall invite the rest of the panelists and discussants to join us here and have the discussion going. Kindly look at the bios of the various speakers, starting with Mr. Kagoro and the other four discussants, so that we don't have to go over them in the interest of time. Without much further ado, let me now invite Mr. Brian Kagoro to talk to us on the role of the legal profession in advancing access to justice for victims of historical crimes. Brian.
Excellencies, it's a privilege to come and address this august assembly. And I think to start my address, which is looking at the role of lawyers in issues of reparations, by referring you to a story, the story of the Herero and the Nama people, the genocide against the Herero and the Nama people, which was a campaign of ethnic extermination and collective punishment waged against the Oha Herero and Nama in what was then German Southwest Africa, now Namibia, by the German Empire. And that should really go down in history as the first genocide to begin in the 20th century, occurring between 1904 and 1908. In January 1904, the Herero people, who were led by Samuel Maharero, and the Nama people, who were led by Captain Hendrik Witbooi, rebelled against German colonial rule. On 12 January 1904, they killed more than 100 German settlers in the Okahanja. In August 1904, the German general Lothar von Troika then defeated the Herero in the Battle of Wattenberg and drove them into the desert of Maheke, where most of them died of dehydration. In October, the Nama people also rebelled against the Germans, only to suffer a similar fate. Between 24,000 to 100,000 Hereros, 10,000 Nama were killed in the genocide. The first phase of the genocide was characterized by widespread death from starvation, dehydration due to prevention of the Herero from leaving the Namib desert by the German forces. Once defeated, thousands of Hereros and Namas were imprisoned in concentration camps, where the majority died of diseases, abuse, and exhaustion. This story should be juxtaposed against the story of the Khoi and the San people of South Africa, who at the time of Jan van Riebeck's arrival in the Cape of Good Hope, were fairly wealthy. They had lots of cattle, and the new settlers conscripted or took away the cattle that belonged to the Khoisan. And not only that, then they began a purge, a near genocide. So the Khoi and the San lost lives, they lost property, and it is that property that made the new settlers very wealthy, as they became suppliers of all other merchants passing through the Cape of Good Hope. And the third story is the story of the chiefs in Zimbabwe who rebelled against colonial occupation in between 1904 and 1918. These chiefs, upon defeat by the British, some of them, Chief Chingaira and others, had their heads decapitated, and the heads were taken to London as trophies. You have similar stories across the whole of Africa. In East Africa, under colonial, the treatment of Kenyan workers and those who dared to rebel in Kenya by the British, the exiling of the Asante Hin, and the looting of Benin bronze, and many other such acts. But these acts find a parallel in the Caribbean, where the first slave plantation, chattel slave plantation, was established in Barbados. And we have to link several things. In Barbados, in the establishment of the first slave plantation, certain things happened. There was legislation, or there were laws passed. One of those laws was the law that designated that black people were not fully human. Once designated as not fully human, they could be treated as property or chattel. And this law was translated or transported or exported into Virginia, into the United States, into Jamaica and other islands and parts of Africa. In the legal imaginary of what lawyers can do in dealing with the question of reparations, it is important to understand this history in three ways. The legislative accompaniment of racial prejudice, of dispossession, of enslavement, and of colonialism, and of Cold War atrocities. So there were laws. First set of laws in Barbados said black people were not fully human, as if because they were not fully human, they couldn't be deemed to be entitled to rights. Later on, in the judgment of the Privy Council in 1918, in the case of In Re Southern Rhodesia, the British judiciary ruled that the natives had no sense of ownership, and therefore these who were not fully human could also not have a sense of ownership, therefore setting the stage for the colonial plunder that followed. So when we're talking about reparations, we're in essence talking about serious violations of international human rights law, international humanitarian law. And I want to get to, in setting my agenda, suggest to you that there are historical questions of atrocity, which I have enumerated, historical questions of impunity, and then there are questions about what sort of repair do descendants of those worst affected, as well as some who may be living, deserve under international law and if at all. And how does this relate to current narratives of transitional justice and the questions of remedying the past, and what might be the role of lawyers? In essence, there are continuities that we must appreciate in both Pan-African thought and activism, quest for dignity, humanity, freedom and justice, and practical solidarity. The linkage between chattel slavery in the Caribbean and in parts of Africa, and the resistance to slavery and the consequences that countries such as Haiti suffered, 19th century colonial occupation, resistances that followed, the quest within the Pan-African movement and other movements for justice, for liberation, for freedom, and the new quest and questions regarding reparations for that slavery. They are anchored on the following, in these continuities. And these continuities face frame future imaginaries. They are anchored on quest for dignity, for justice, for freedom, for equality, for development. Quest for repatriation of those things that were stolen from Africa, and for reparations. Because it is assumed that this is the only way we can achieve recognition of the atrocities that were committed, but also a way to achieve this sort of economic and structural transformation, political participation and representation that is desired. I want to bring this into a new conversation. That new conversation is a conversation of the legal basis. This legal basis pertains to the following: the requirement for a holistic approach to understand who was harmed or who is harmed, by what and how, and the intergenerational trauma and the opportunities that are there for law, and how repair can occur for the criminal acts that were taken, and the economic losses, the social, cultural, environmental, and psychological harm that may have been historical, but that are continuing, and the role that's played by the multilateral system in sustaining anti-blackness, and what it might mean to for lawyers to be part of constructing the liberation. So reparations demonstrate the imperative of justice and repair for the past, for slavery, for colonialism, for apartheid, and the Cold War. And the legacy of colonization and contemporary implications for human rights and economic development and social justice must be appreciated as being conjoined and inseparable. And the connections between anti-black racism, foreign policies that we see that undermine and support the pillage of Africa, and new questions such as the climate question are worth understanding in this light. So when you look at gross violations of international human rights law, serious violations of international humanitarian law, you may wish to ask their rights to repair in international law. So I want to suggest that is a generally accepted legal principle that international law that was set in the Chozo case, the Chozo factory case, by the Permanent Court of Justice in 1928, which says in international law, the breach of an international obligation involves an obligation to make reparation in adequate form. So that the reparation must, as far as possible, wipe out all consequences of the illegal act and re-establish the situation which would, in all probability, have existed if the act had not been committed. So there are certain basic principles and guidelines that guide this right to remedy for victims, and this is set out in the UN Resolution 60 of 147, Principle 2 of March 2006. And I want to also refer you to the ICJ judgment in the case of DRC versus Uganda, in which the ICJ ruled that injury caused to an individual is relevant in assessing the scope of reparations owed. And in our view, there are certain things that are key, which are the 3 levels enabling an individual to obtain reparations at international law. The first, if you look in practice, is at an interstate level, it's diplomatic protection. And this is set out in the International Law Commission draft articles on diplomatic protection. At the second level is at the international level, where reparation is through international and regional tribunals, as well as treaty bodies, which allow individuals to bring complaints against states for violations of international human rights law and international humanitarian law. But there is a general understanding that they must first exhaust domestic remedies and not abuse the international fora. And of course, there is at the national level, individuals can bring reparative claims before the domestic courts of a state. This is assuming that there are mechanisms, and in most instances, and in the particular case of reparations for colonialism and for the Cold War, and simply do not have the platforms and the facilities to entertain these claims. So if you look at reparations in international and regional human rights treaties, whether it's Article 2.3 of the International Covenant on Civil and Political Rights, Article 6 of CEDAW, Article 14 of the Torture Convention, and Article 24 of the Convention on Enforced Disappearance, the articulation of the right to effective remedy, which encompasses both access to justice and reparations, as well as the articulation within domestic and regional tribunal and some of the transitional justice fora, does not cure one thing. There is no specialized forum at the international level or regional level for victims of colonial injustice and slavery to obtain relief. Which then begs the question, what might be some of the hindrances to people obtaining relief? The first is statutes of limitations and the affliction of time. The second is the question of choice of law. Most violations were committed by people who were acting arbitrarily and sometimes outside the jurisdiction and control of the law of their state of origin, but who were acting in violation of laws of the recipient states, whether these are customary or traditional laws. Number 3 is the principal subsidiarity of international mechanisms and the procedural obligations of state. In most instances, I think this principle of proportionality. What is the proportion? What are the considerations when it comes to proportionality of repair? If you look at some of the egregious crimes committed under colonialism, during slavery, and during the Cold War. and what is the position and space of collective repair versus individual reparations, and what might be the place for ad hoc system of reparations and friendly systems that are not, if you like, adversarial. Of course, in using the term reparations, there are three different types of reparations, which is the restitution, compensation, satisfaction, guarantees of non-repetition. And in each of these, the circumstances and gravity of the breach determines the appropriateness and the nature of reparation. So I want to suggest that this frames the role of lawyers as follows: that members of the legal profession clearly have a lot to do in terms of legal research, legal education, legal access, legal empowerment, and broadly legal scholarship to expand the ambit of the jurisprudence. And then, of course, there is the practical action of strategic litigation to bring emblematic cases, whether it's the case for the reparations for Vaherero and Nama people, or the reparations for the Khoisan people, or reparations for the Shona people and other civilizations that were
Thank you. Thank you very much, Mr. Kegoro. Mr. Kegoro is the Managing Director of Programs at Open Society Foundations. And he's given us, let's call it a tour de force on the subject matter. Now, I would like to invite the discussants to join me up here so that we can take this conversation forward. First and foremost, Dr. Catherine Namukula, please join us. Dr. Namukula is a distinguished human rights academic and advocate, and is a senior lecturer at the University of Free State in South Africa and professor of human rights and criminal justice at the Global Humanistic University. I can't pronounce that name. Thank you. Then we have Henrietta. Yes, Henrietta Ekifre. Henrietta is just trying to get your bio. Is a legal advisor managing the African Reparations Program at Africa Judges and Jurists Forum. Her current work focuses on reparations for historical injustices, including colonialism and transatlantic slave trade. Welcome, Henrietta. Mr. William Carew, is he here? No, we don't have him here, and I don't think we have him online either. And finally, Mr. Waikwa Wanyoike. Let's give him a round of applause as he gets up here. That Mr. Wanyoike is Director of Strategic Litigation at the Open Society Justice Initiative. So thank you very much, our discussants. We've listened to what Brian Kagoro has presented in terms of the different nomenclature and permutations of historical injustices and the legal mechanisms that exist and the limitations that also exist. He's called for a lot more work in terms of jurisprudence and a lot more work in terms of scholarship. I would like to invite you to take turns and speak to aspects of this subject. I'll give you about 7 minutes each, right? Yes? And then we shall open it up for discussion and conversation. So we begin with Dr. Namakula, please.
Thank you, Mr. Moderator. All protocol observed. I bring you greetings from the Working Group of Experts on People of African Descent, the UN, where I also sit and deliberate on some of these matters, and the Africa Reparation Hub that I'm convening at the University of the Free State. I'm very delighted to share this discussion with the panelists, many of whom are colleagues that we have been actually struggling to push this movement forward, especially the AJJF and the Open Society. I'm particularly grateful to our colleague, the Secretary General, Mr. Martin Masiga, who at the launch of our hub did make it categorically clear that we need to popularize this movement other than eliticize it. That has remained stuck in our mind. And with that, we are working on a database on Africa Reparation Agenda, and we are calling for all contributions, any information, papers that you may have, information or historical information that you may have on the historical injustices to Africa, so that we can add them to our database. We don't want to restrict it to scholarship, which has suffered from a lot of gatekeeping and colonial narratives that we want to really change. We are also extending an invitation to you to contribute to our book on principles, guiding principles on reparation to Africa. Right, thank you. There are key developments that are happening in this regard, and one of them is the declaration of the AU of 2025 as the year for reparation. And we look forward to that, and we look forward to you joining us in actually building this united front that the AU has called for reparation in Africa. This last month as well, lawyers in Uganda brought a suit against the Capital City Authority, asking to rename the streets of Kampala that still represent colonial administrators. And according to them, the retention of the names of colonial officials on public infrastructure is a constant reminder of the historical injustices inflicted upon Ugandans during the British colonial rule, and they perpetuate intergenerational trauma and subjugation. Right, so one of the key things that our colleague, senior colleague, Brian Kagoro, talked about was victimization. So when we say there should be reparation for Africa, especially for the 4 centuries of enslavement, and then the colonialism that followed, and the contemporary extortion, people ask us, what cause of action does Africa have? And they say that Africa participated in the sale of its people, according to the historical narrative, which is advanced, which is also part of the victimization that we suffer. So one thing we have to ask ourselves is, does Africa has a cause for action? I didn't say of action, because that's very illegal, for action. And with that, we're advancing 2 points. One, the territory itself of Africa is a victim. It was victimized. And secondly, its people themselves were victimized. Brian Kagoro mentioned the intergenerational victimization of Africans through systems of institutionalized and systemic racism. Of course, since our presidents or our leaders have been calling for change of the financial architecture, global financial architecture, and they have also been evident subjugation of the continent even at the global stage. When it comes to African issues, there is a different attitude to them. And this has been traced to the history of enslavement and commodification of Africans that took place many, many centuries ago, that has never been disrupted in some instances. We see that there is a sale and enslavement of Africans in the Middle East, sale and auctioning of African women in Middle East and Asian countries. There is continuing extortion and grabbing of resources from the continent. And when we tell European banks that they should think about returning that money to where it came from, they talk about things like bank secrecy. And those are some of these. But then people are saying that maybe the perpetuator is changing, yeah, as well, that some perpetuators are from the continent. We are looking at the dumping of toxic waste and environmental degradation by multinational companies here on the continent, unabated. We are looking at the nature of our education itself, even the portrayal of our history as one way of continued victimization, a history that actually represents the dealings of other people on the continent and invisibilizes our contributions and our achievements as a people and as a continent, including fighting off colonialism successfully. Yeah. So we also look at our education, and this is also somewhere where we can get involved when we are talking about the right to education. The colonial perspective, colonized narratives to education that actually do not even articulate the opportunities on the continent. And in a way also examining our graduate attributes. What kind of graduates are we producing? Are we producing for other economies, or we are producing for ourselves? So there was a profound observation made by somebody when we were in these trips to Barbados, and said the moment you put yourself in someone's head, then you don't need to actually enslave them. They will work for you anywhere, wherever they are. So we are looking at some of that, the existence of invisible chains and invisible borders, invisible chains on the minds of many Africans, and invisible borders to Africans and many others. You see how the question of migration is turning out. Right, so in terms of the actions that we need to take, the moderator has mentioned establishing frameworks and structures to advance the agenda, and we have started with resolutions in terms of the normative infrastructure. Now we want to have a committee at the AU level that would actually advance that and guide us on this and how to proceed with that. Then secondly, we have to take jurisdiction over these matters. I'm saying take deliberately, because courts here in Africa have unlimited jurisdiction over all matters, right? Like the High Court in Uganda does have that. So you can hear any matter. But how come we are having these cases being heard in New York? If we think of the Kolomani Action Group that is suing for GM Motors for its involvement in apartheid, we are having these cases going to London. We're going to look at the Mau Mau, who have also sued from there. So all the cases are going there. Why wouldn't we take jurisdiction in these matters? Decolonizing international law. Also recognizing and calling out racism. There is very limited understanding of racism as the contemporary manifestation of all these colonial legacies. Yeah? When you look at some of our judgments, even amongst our courts, we are not sometimes able to understand how racism comes out or plays out. Even in certain judgments where people have been called monkeys and all that, judges have not been able to actually amplify that and its significance on our population and actually translate it into punishable outcomes. We're expecting maybe we can make also bold pronouncements against actions that victimize the continent. And among those include environmental degradation. We have seen a case, Trafigurayas, in the Netherlands. That was a case also about dumping of toxic waste by a Dutch company at the coast of Ivory Coast that led to death of many, many people. It also ended somewhere. Right, so we have a few challenges. Please, moderator, allow me to table these. The countries that are responsible for the historical injustices are not prepared to pay or even consider the question of reparation for Africa. They fought it at Durban. They boycotted the Durban Declaration and Program Action. That's the most comprehensive document that talks about reparations. for Africans. Talks about the victimization, talks about remedies for victims. It's very comprehensive. That was boycotted for a reason. So they are prepared not to make good, much as there is precedent. Yeah? We are saying there is a case because there is a precedent. The Jewish conference, up to now, they're receiving paychecks. There were black people among those, but nothing has been mentioned about them. The Holocaust was not all about others. It also included black people. Right. So there is precedent that other people have received reparation. Of course, we can see that Ukraine, there is already a resolution for reparations for Ukraine, but when they talk about reparations for Africans and black people, we hear resolutions, we hear study, we hear inquiries. That's what we hear. We don't hear the movement going forward. There is an issue of jurisdiction, courts actually establishing jurisdiction over this. Something maybe could come from the African court as well. So there's an issue of jurisdiction, there's an issue of research. We don't have much information. Why? Because much of our information was passed on through oral tradition. It would surprise you that the Mau Mau litigation only moved forward after researchers from the UK, University of Warwick, came here in Kenya and made findings about the victimization, the gruesome violations that happened here. But there were researchers here in Kenya. That may also come from what is happening, that when actually people write from the continent, then we have to submit to certain journals that have Mr. Smith, Miss So, also considering those publications before they are published, and sometimes they reject those narratives. And that's why we are making our database very open and not really restricted to what is known as a contemporary standard or previous standards of scholarship. Thirdly, we depended so much, our human rights work has depended so much on Western funding. Actually, when you invite people to have even a dialogue, they want to know whether there is money coming from somewhere. There would be, we can also expect that there would be no funding for this from the countries that actually perpetuated those various wrongs. So that we cannot expect. International law itself is biased, so if you are looking for an existing framework to actually drive this agenda, it might not be the one unless there are creative ways of thinking around this. Yeah? So we need to decolonize already international law that we have. We are also confronted with damage that was done for centuries. 400 years of enslavement. We are talking about also many decades of colonization and now new colonization. So how do we quantify that? How do we confront that? That we ourselves also have been socialized and educated into perpetuating colonial narratives. Yeah? We're looking at a certain case in South Africa where the judge, the litigants, the lawyer spoke one language, they proceeded in that language, and there was a judgment. They're like, we can understand one another, we are proceeding in an African language. And the higher court, on appeal, on review, did say that it's not a best practice, we cannot proceed that way. But why not? Thank you.
Let's give Catherine a round of applause. Thank you very much, Dr. Namakula. Let me now invite Henrietta to just give us her perspective on this question.
Good morning, Honorable Justices. I'm going to stand on already established protocol. So my name is Henrietta. I'm a legal advisor on the Africa Reparations Program at Africa Judges and Jurists Forum. And in my 7 minutes, I'm going to quickly speak about some of the work we've been doing in this space and also respond to some of the points raised by our colleague, Mr. Brian Kagoro, as well as Dr. Catherine here. So to begin, we must first, I imagine that we all accept that the injustice of slave trade, the transatlantic enslavement of Africans, and colonialism are atrocities. The Durban Declaration that have been spoken about in 2001 did clearly state that slave trade is a crime against humanity, but didn't go as far as establishing colonialism as the same. So that's already a problem. Because then when we're talking legally, we can't say we are allocating any international legal obligation to colonialism as a legal issue. But for slave trade, we agree. Now, we've established some of the challenges in terms of getting access to justice, which we spoke about, one of which is statute of limitation, which Mr. Brian Kagoro mentioned. But interesting to note that Article 29 of the Rome Statute did say that statute of limitation cannot apply to crimes against humanity. But for some reason, we are not able to bring cases on this issue at the international level. To reference the cases that have been mentioned, one, the Mau Mau case, indeed that case was ruled at the UK court, and the UK court then established that the government of the UK was responsible to pay reparations to the Mau Mau people, which came to 19.9 million at the time. And the state then had tried to make a case that the Kenyan government should be responsible because after independence, the people did not get reparations. And so I'm just raising this to say that one, reparations is valid, but we must get it from the international level as opposed to African governments. I do not think that African governments are to be held responsible for historical injustices in this case because we were all victims for historical injustices. So I'm just going to backtrack a bit. What can we do as lawyers and judges in case of reparations? One, promote legal accountability. We've spoken about how there is no legal framework for reparations. And we can promote that through advocacy. We can promote that even through reforms of education processes, which has been mentioned. I am a lawyer, studied through first degree, master's, and all of that, and not once was I lectured on reparations for historical injustices as part of the curriculum. That is something that we can do. Yes, our courts may not have the jurisdiction to review cases of historical injustices because at the end of the day, who is liable? It was established that we cannot hold African governments liable because at the time they weren't actually established as governments the way they are now. And the international system is flawed that we can't hold the colonizers accountable because there is no law that we can use. What can we do? One, advocacy like I said, but secondly, putting it in our curriculum that we understand and lawyers are able to engage with reparations as an international law issue, but also pushing for a legal framework at the international and regional level. The African Union has held several conferences on reparations, and as of 2023 February, the Assemblies of Heads of State adopted a decision calling on the African Union Commission, ECOSOC, and other organs to develop a common African position. Like Dr. Catherine said, we've been working closely and trying to examine what is this African position. Taking inspiration from the CARICOM, which is the Caribbean community, they established a 10-point agenda plan as of 2013-14, about 10 years ago, that lists out what they want as a community. As Africa, we don't have that yet. And just for reference, I'm going to highlight some of the things that are in their reparations plan. One is requesting for a formal apology. A second is repatriation of Africans and people of African descent back to the continent, so return settlement programs. Another is cultural institutions, establishing cultural centers and institutions that promote the knowledge of Africans and indigenous people. Calling for acknowledgement that some of the public health crises that we as Africans have faced have a colonial past as well to it. Colonial past and the slavery aspect of things has affected our public health structure. Illiteracy eradication, African knowledge programs, technology transfer, and debt cancellation. If I can focus on one of the things they listed, it's debt cancellation. If we look at the current architecture and how formerly colonized states are indebted, impoverished, are lower on the GDP scale, are lower on the economic indexes, as opposed to the former colonizers, we can certainly make a point that debt cancellation is a form of, can be a form of reparations that we can advocate for. And so at the African Union level, one of the points that came out from the proclamation of reparations, basically from the Accra conference that happened in 2023, a document was adopted, which highlighted some points that the African Union wants to proceed with. One of which, like Dr. Catherine has mentioned, is establishing a committee of experts on reparations, establishing an AU special envoy on reparations, and establishing a global fund for reparations. What does that global fund look like? And so for us as lawyers, as judges, our role is to support this work regionally, support this work in developing frameworks so that whatever the institution, the African Union, does proceed with, we're optimistic next year, hopefully, that this committee would come into force, that we're able to support the work, not just with legal arguments, but also advising on what, practically speaking, what the frameworks would look like and how they could be implemented. I just wanted to speak a little bit about the ongoing effect of historical harms. And in the case of Namibia, our keynote speaker mentioned the Nama Herero people and how the genocide that happened about 100 years ago happened and how it continues to affect the people. So a few years ago, Germany did issue an apology and then, well, issued a regret and then negotiated with the government a reparation sum of 1.1 billion, 1.1 billion euros to be paid. And the Nama Herero people have basically opposed that process to say they were not consulted. Now, in contemporary times, how does previous or historical crimes continue to affect the people? In the case of Nama Herero people, the camps where they were kept in and genocided is Shark Island. And Shark Island is very close to the sea. And now, looking at how this links to climate justice, there is a movement for hydro energy. And there is a German company now that has gone into agreement with the state to establish a port in Namibia from Shark Island going into the sea. Why is this a problem? Some of the ancestors of the Nama Herero people who were genocided were buried, should I say buried or thrown into that ocean, right? There's this forensic architecture, they're called. They have done research to show that there are still some remains of people who were genocided on Shark Island. Now, having a company or having the state go into collaboration with the company to develop a port, because that's going to yield development for the people in general, is insensitive if it's going to happen on Shark Island, where the ancestors of Nama Herero people are. And so what they have done is file for an injunction in the local court to stop that process, because construction should start in January. And as of July, they filed an urgent appeal at SED, the Committee on Elimination of Racial Discrimination at the UN level. So as judges, as lawyers, domestically, that's an example of historical injustice that continues to affect the people. And even though there is no law within our domestic system to criminalize things, we can support the cause. For example, in Nama case, we can support the cause, we can advocate, show them support, develop frameworks within the system that would not ensure that colonial injustice continues to happen. Another example, or rather a challenge that affects reparations for artifacts, for instance. In the UK, there's the British Museum Act that actually stops UK museums from repatriating artifacts. So you hear cases like in Ghana where some museums have loaned stolen artifacts to the kings in the Kumasi region. Loaned it for a bit because they cannot actually return it. What are we doing as a legal society to establish our own framework to say this thing must be returned and it is our right to have it? These are all questions I'm posing to your honorable justices. I look forward to discussing more on this issue. Thank you very much.
Thank you. Let's give Henrietta a round of applause. Thank you, Henrietta, for those comments and for loaning us your mind on the subject. Waiko Wanyoike, you have your 7 minutes of fame.
I don't even know how to turn on the mic, and that's where my fame starts. I wanted to use my 7 minutes to try and do two things. The first one is to highlight one part that always gets missed when we talk about historical injustice, and that is the place of art and artifacts, and the question of restitution and repatriation. And the second thing I want to talk about, which is what my colleagues have already done, including Brian, is just to highlight, especially given that this room is full of judges and lawyers, some of the pathways of justice in the context of historical injustices. So when we tend to talk about reparations, we do dwell a lot on historical injustices that are specifically related to colonization and the abuse, torture that occurred as a result of colonialism. One thing that tends to be missed a lot is the amount of stealing, and I'm using that word very intentionally, of art, artifacts, and items of culture from the continent, and how a lot of those items of culture, even today, sit in the global north capitals. So just to give you an example, and the question about the British Museum was brought up, but just to give you an example, the Jacques Chirac Museum in Paris has about 90,000 artifacts from Africa that were taken during colonialism. All those arts sit there. There has been efforts by communities to try and seek repatriation or return, but that hasn't been done or has not been achieved, other than for very few items. So the critical point here being that as we speak about reparations and historical injustices, we should not miss the place of culture as a space for contestation of these issues. I want to refer you to a very, very elaborate report on stolen art and artifacts done by two Senegalese, Felwin Sall and Savoy. This is, I think, a 2019 report, which is available on the internet, and the level of root that is documented there, and the difficulties that communities have gone through to try and get their items is quite telling. The second thing I said I wanted to do is to talk about pathways of justice. And I think for me there are at least 4 pathways of justice that lawyers and judges need to really pursue comprehensively. The first one is obviously domestic. And the best example in terms of the domestic as a domestic forum is the Namibia case that has been highlighted a few times. And why Namibia case is interesting is because the communities, the two communities, the Herero and Nama, have gone to court to say that the government betrayed the people, or its own people, by negotiating an opaque deal and settling for amounts, first of all, characterized as development aid, which will be paid over a 30-year period. And as already indicated, only 1.1 billion euros. So it's not even a significant amount of money for communities that in 1904 lost about 100,000 people, the biggest genocide ever recorded, the first and biggest genocide at the time. So you can see it's a serious question. But the creativity for me is that what the lawyers have done there is to just emphasize on the principle of public participation and community and indigenous communities' right to participation, and that is the grounding of the litigation. The second is a challenge. Most of our constitutions contain the right to culture. In Kenya, for example, the Pokomo people from the coast have been trying to get some of the artifacts that were rooted for a long time. For me, domestic jurisdiction are critical in terms of helping communities get ways to negotiate for this return. So thinking about Kenya again, I don't see why it's not possible to bring a case under the right to culture, requiring that government does enter into negotiation with governments of countries where these arts and artifacts are stashed abroad. And I think there might be a really good pathway for litigation, partly because it also challenges the question that foreign policy can only be engaged by governments. The second, and we can discuss more about potential cases for the future, but the second is obviously transnational options, and the case of Mau Mau get highlighted a lot here, and luckily one of the lawyers involved with the case, the Honorable Gitobo Imanyara, is with us here. But the Mau Mau case actually showed the possibility of transnational litigation in terms of giving communities justice. The two key issues that came up, the challenges that were being highlighted, there was the question of statute of limitation, and the court actually refused to accept that given the nature of abuse. And the second, which hasn't been highlighted, but which I think would come up if these issues ever came to your court, is this issue of state succession. And the argument, which was obviously extremely ridiculous, was that once the torture and the harm that was subjected to Mau Mau by the colonial government was succeeded by the independent state of Kenya upon independence. And so the people who owed any damages to the Mau Mau was the Kenyan government and not the British government. I just wanted to highlight the state succession issue because I thought it hadn't come up. The third route for all this is the treaty mechanism, or UN treaty mechanism. And there are two. One has been highlighted. The third option, at the moment we are looking at possibilities of bringing a case before the SAD. The SAD is the Committee on the Elimination of Racial Discrimination, and they have a mechanism where either states can make a complaint against another state, or civil society and other groups can actually bring a complaint. State or interstate claims are quite easy to do. In terms of procedure, they are difficult because states don't want to take other states to court. But it does present an opportunity in terms of domestic court, going to my first point on the right to culture. If we had an issue with one of our governments where the government is failing to facilitate communities to achieve justice, might it be an appropriate order to seek in court asking the state through a structural interdict to pursue an interstate claim at the Committee on Elimination of Racial Discrimination? I would be interested in that. The second, which hasn't been highlighted and which actually is specific to reparations, is a UNESCO mechanism. Where it's possible to complain before the UNESCO. It's more of an investigative process, but still bears some characteristic of litigation that one can use, especially when it comes to historical injustices relating to art and artifacts. And then finally, and this is my last point, I know I'm running out of time, is the international mechanism. And two, I would like to highlight. We've seen the potency of ICJ in the context of the South Africa-Israel case. That's just one issue. Why are we not seeing similar when it comes to historical injustices of colonialism with African countries leading in that way? And there has been efforts, and I think Haiti and the CARICOM have been looking, the Caribbean region have been looking at the possibility of that. Of course, there are challenges about limitations and others. But the second, which is closer to home, and which I would challenge all of us to look into, the African Court has an advisory jurisdiction mechanism. And the good thing about the advisory jurisdiction mechanism of the African Court is, while it's a state, it's available most only to the states, there are two organizations, NGOs, that have the facility, or they are enabled to seek an advisory opinion. And so why are we not asking as a continent for the African Court on Human and People's Rights to actually provide an advisory on the issue of historical injustices, colonial crimes, reparations, and others? Thank you very much.
Let's give a round of applause to Waikwa. Thank you, Waikwa. I think we've had very, very rich presentations from our lead presenter and the discussants, and I want to open the floor for questions and comments. And as we do that, let me just pose a question or two for the panelists to consider. One, I think President Thabo Mbeki has been leading some initiative around illicit financial flows. The drama around colonialism, slavery, and so on, makes it very visible for us to see the historical injustices around those processes. But there is the question of illicit financial flows, which occurs without the manifestation of violence that we saw in the period past, which is tied to something that this country is dealing with, a question of odious debts. Should we begin to frame this silent extraction of resources under the guise of trade, under the guise of aid, or under the guise of debt, as a key component part of the historical crimes that need to be attended to? Is it an invisible, just like the artifacts sometimes we tend to forget? Is it one of those that we need to begin to look at? Then the second question I would invite you to think about is the complicity of the African elite in delaying justice for historical crimes, victims of historical crimes. And here, the question is, how are contemporary crimes? We have genocide in the Sudan, for example. We've had serious human rights violations in other parts of Africa, post-independence and currently. I'm calling them contemporary crimes. How are these contemporary crimes hurting the quest for justice for historical crimes? Is there a way in which the happenings that are taking place currently are interfering with the clarity and the strategy around justice for victims of historical crimes. Let me open the floor. Let's have comments and questions. Justice Lenaola, then 2, 3, 4. Let's start with those 4, then I'll come back to you. Justice Lenaola.
Thank you very much, and the presenters have important issue. Let me speak generally about effective relief.
I don't think we can hear you. Put it closer.
Sorry. Yes, it is. Effective relief, which Brian Kagoro spoke about. And I just want to point out on 2 examples. One, in New Zealand, after about 200 years, the Mabel case was filed, and the British government was forced to acknowledge theft of land from the community. And the question then arose in the Mabel case was, what would be the effective relief to the community? Do you give them land? Do you give them schools? What do you give? The second example is to the Mau Mau case. What would have been the effective relief to the Mau Mau people? Is it cash? Is it something that is community-based? And I'm giving this in the context of a case that I handled when I was a lawyer, an advocate here. I come from the north, and the Brits have a training camp in my locality, and for a number of years they were abandoning munitions and exploded bombs, which took out a large number of people in terms of limbs, in terms of life, in terms of everything really, animals and so on. And Martin Day, who also handled, together with Gitobo and others, the Mau Mau case, then came and filed a claim in the British courts. And I was initially involved, but along the way, the politics of the case came in, and I had to resign from representing my people. But the result was that the British government settled the case and paid my people 450 million shillings then, in 2001. That's a large number for people who are pastoralists, 3-4 cows. That's a lot of money. But the result was that people are getting 13 million, 10 million, 3 million. Every one of those people now, those who survived and their families, are exceedingly poor. None of them is anything to speak about in terms of the millions that they got. Was that an effective relief to these people? And so, Dr. Namakula and the rest of you who are involved at a deeper end in this question, we must, as we go on and have this conversation, in my view, be clear in our minds that the relief we are getting from the perpetrators must be effective and long-term. People were buying RAV4s, they were buying mobile phones before network arrived in my village. They were saying, we shall wait for network to come, we are millionaires. Was that an effective relief? So I think for me, that conversation must continue the way we are going. And lastly, when the late Wangari Maathai was alive and was leading the reparations conversation here, she was being bashed for, why don't you let sleeping dogs lie? How do we then address the elite question? That the elites of this country and the elites of Africa are themselves saying that conversation is dead. Let us think of Africa into the future. And I'm saying this because, again, in Laikipia, in this country, when the Brits came, a lot of land was given. Today we have people in this country who are sitting on 100,000 acres of land, while other people have nothing to live on. And when we were fighting to stop the renewal of the leases, when we were having this constitution for Kenya, the elite of my region were the first to advise them to renew their leases before the constitution came and reduce the leases to 33 years. What is the role of elites, and how can we ensure that we as judges, those who are elite in the legal profession, do not fall into this trap of being perpetrators of continuing injustice against their own people? I thank you.
Now, as the mic is moving to no, it was her. Justice Lenaola's comments has reminded me, talking of scholarship, a professor of mine here, Professor Nangwe, did a paper on titled "When Peasants Encounter Capital, What Happens?" The political economy of sugarcane growers in Western Kenya. That's what you're talking about. So I think as part of the scholarship around this question, when these communities encounter capital, what happens and how do we avoid the sort of pitfalls that Justice Lenaola is talking about? Yes, please.
Thank you. It was a very rich discussions from the panel, and I congratulate you. I have a very simple question regarding we are talking about crimes that happened decades ago, centuries ago, colonialism and slavery. And I wonder what would be the victim in such crimes. Is it an individual or is it the state? Because now that many years has passed, I don't think it is possible to identify the victim. Or maybe in the international jurisdiction, there's a mechanism or a legislation which provide clarity as to who qualify to be a victim of, in the context of a particular historical crime. That's my question. Thank you.
Thank you. Yes.
Thank you very much for the floor, standing on our protocols. First of all, I would like to congratulate the moderator for setting the stage very well. You did not miss any of the 4 pillars that we identified for reparation last year when the AU hosted the reparation conference in Accra, Ghana. I would like to say that just to add on to the other speakers who have done a wonderful job in presenting to us the elements that constitute reparations and restitution, to say that the African Union has actually adopted 2025 theme for the year as looking at people of African descent. And so this is a very timely conversation. Momentum is very important at this moment because we were starting to lose traction, I would say. And so it is very important that conferences like this descend from a Pan-African perspective on what is happening in Namibia and put support or show that Pan-Africanist approach to what Namibia is doing, because that would do a lot of good to the people in Namibia in terms of inspiring them and in terms of the global message we'll be sending, that anytime an African community comes up with a matter, it is our matter. And so this is maybe a recommendation. But I also wanted to say that we learned from the Caribbean that they have made a lot of progress on reparations. And it is very important to ride on what the Caribbean have done in terms of pushing the global reparation agenda forward. I also thought that there was a mention of language somewhere, linguistic, culture is embedded in language. And so I don't know whether our courts have time to understand some of, to give that space to people who want to express themselves culturally. And if they are trained to break down this into the legal system. One of my mandates in the commission is to protect the rights of indigenous communities and minorities in Africa. And I think we have a lot of elite pushback. And I'll give you an example. We tried to introduce the use of African languages at the cross-border for the African Free Continental Trade Area, the FCTA. And the idea was, look, although we are talking about African Continental Trade Area, we know majority of the trade that happens at cross-border is within communities. They speak local languages. So why are we bringing Portuguese, Arabic, English, and French to the cross-border transactions, at least for 70%? Why don't we allow our people to transact in local languages? And there was a lot of elitism, like, but this is not ACFTA, you see? So we need to deal with ourselves. English is not it. We have to understand that if we are going to fight for some of the reparation we are talking about, culturally, we need to talk culturally. So just to wrap up by saying that I was in KZN last week for a ceremony, and the representative from the Khoi people came to me and told me, we have been looking for you. We have a problem because in Cape Town, there was a monument that had been erected by the apartheid government, which was like their reparation to the Khoi people, because during apartheid, they used to kill the Khoi people, murder them, and burn them. And then after some resistance by the Khoi people, they thought it is even wiser to chop off the head of the Khoi and take it to Cape Town, and it's easier, it's simpler. So when the Khoi people pushed for this injustice to be dealt with, a monument was erected where the urn, where they used to burn the head of that they cut from the Khoi. So they were telling me now this monument is supposed to be removed by developers. So what we are talking about in Namibia is happening everywhere. And I do not think these things are isolated. It is a way of trying to kill the movement and the pressure that our people are trying, and to make sure it's forgotten forever. So they were telling me, we need you to write to the government to say that that urn is the only thing we have to remember our ancestors. Why can't they go and get another site to develop? So these are serious matters. And I think a meeting like this helps us understand that if the Khoi have an urn that they are fighting for, which is the only thing they remember for their past, then a Pan-Africanist organization like this should descend on a matter like that, because next time it will happen elsewhere. So this is really the link I wanted to bring, and there's so much to say, but we have to respect time. Thank you.
Thank you. Mr. Masiga, maybe you may want to consider reparations as a standalone theme for AJJF as we go into the future. The last...
I think you had given...
No, I'll come back to... I'll come back to you, Justice. You were the fourth one. No, I think it was over there. I'll come back to you.
Again, thank you very much. Apologies for my English, my broken English. I wanted to thank the panelists for the quality of their contribution. I have learned a lot. And I would like to encourage them to the reflection, action, and to bring forward the cultural crime and reparation. But I would like to, at the same time, based on the Senegalese experience one month ago, the new authority have organized a national dialogue on justice and have invited more than 1,000 citizens, judges, lawyers to do a diagnostic of justice. I had the privilege to be the scientific commission to preside it, and the report have been given to the new authority 1 month ago. What was told about access to justice? Because some cultural artists have brought this question of reparation on discussion. But many others have told, yes, it's something to encourage, but at the same time, Senegal and Africa in general are facing a more urgent problem on access to justice, which is how our poor population, rural zone, have real access to justice in our different country and in Africa in general. When you see a country like Senegal with 16 million of population, we have one judge for 100 habitants. And a platform of discussion have been opened, and we realize, despite our efforts, that the justice system is criticized by the population in general because they have no access to justice. Access to justice is not just litigation, it's the services you got from the courts. It is the quality of the documentation you can get. It's the quality of the documentation on time. But when you put all this on the table, you realize that your effort to continue to struggle internationally to get reparation, this money, these efforts have also a double approach to do, and to bring your effort locally to try to bring African people who have not enough means, enough resources to get justice. Getting justice is like having access to water, to electricity. It is a human right. And what have been done in our different countries to be sure that our population are happy in the way justice is given, justice is seen given, and the quality of services requirement has the minimum standard to allow any citizen in Africa to get his justice. It's also this approach I wanted to bring on the table.
Thank you. I'll take just the last two so that the Director of Programs has signaled me that time is running out, but she also wants to speak. Conflict of interest. So we'll take Washuka first, then Justice, you'll be second, Judge, you'll be third. Let me see. Okay, the lady. 4. Brief, quick and brief, so that we give the panel a chance to respond. Yes, Washuka.
Thank you. Thank you very much, moderator. I will not take long. But everything in the world today revolves around the operation and power of the capitalist system and on patriarchy. I know that when you introduce these two aspects, the conversation gets very deep. And those two are anchors of oppression, enduring oppression. And my question to the panel is, are we thinking of challenging the language of money? Because even when we talk about reparations, we are talking about being paid in capitalist terms and being stratified in a patriarchal sort of concept. Are we considering the manner in which our societies have been encumbered by modernization, how we have altered culture and identity? Speaking of Namibia today, I was recently in Walfish Bay and Swakopmund, and if anybody told you that that is a European sort of in Africa, you would not be wrong. So even as we are continuing to challenge these concepts, are we challenging capitalism? Are we challenging patriarchy as enduring levels and as enduring components of oppression? Because patriarchy impacts leadership. And when our leaders get into closed rooms, mainly male, they negotiate oppression. So how are we going to win against this war when even our leadership is actually anchored in those traditional concepts of oppression?
Thank you, Washuka. Justice.
Thank you. So I think the first was going to be a clarification, and I think it would have been more helpful maybe it came earlier. So the AJJF has a standalone program on supporting reparation or reparative justice. So we are having this conversation in the context of that program. And that program has been there for the past 1 year now. One of the major things that we have done under that program is to facilitate an engagement between the African Union and the CARICOM. We organized a study tour and took a number of African AU member states ambassadors who are directly working on reparations to meet with their counterparts in the Caribbean. They were accompanied by scholars, jurists. We had Chief Justice Othman amongst us. We had also Catherine here, there, and a whole lot of, it was a very big 1 week almost study tour, and they came up with resolutions on that. And the other thing that we are doing as AJJF is that we've been providing technical assistance to the to SIDO and to ECOSOC. So we are very much engaged on this, but I think what is necessary is to also mobilize the legal profession to play its part. Now, to my question for Waikwa is this. I have a paper that is just about to come out on this question. And one of the issues that I grapple with is the limitations that are there in the international legal system. You would know that there is probably no tribunal in the international legal system that has the mandate or jurisdiction to deal with this particular question. The ICJ doesn't have. So you raise a very important point about exploring the possibility of using the national legal systems. And I think there could be potential for success. But there comes in Justice Lenaola's point, right, which I think could partly be explained by, and it's also coming out in Namibia as well. So when these cases are being decided, there is one topical complaint that always comes. It is about the right of the affected people to participate and meaningfully contribute to the resolutions on what these reparations include. This is the case that is in Namibia at the moment. What is actually happening, and maybe this is also a point that you can take note of, Commissioner, what is happening is that the governments are reaching deals, agreements with the foreign governments without actually consulting the victims. And as a result, the decisions that are made and the distribution of those reparations is what is creating the problem that Justice Lenaola just highlighted now. So the question is, how do we ensure that even as we use the national tribunals to deal with these questions on public participation and so forth, what can be done to tackle counter arguments such as, no, you see, these are international agreements where the executive has discretion, and in some cases may actually not be questioned or may not be reviewed through the courts and so forth. How do you deal with those arguments? Thank you.
Thank you, Justice. As the mic travels to Judge here, the African elite is a serious menace. So when the artifacts, when Yiki was talking about come here, they'll probably auction them back. Judge.
Yeah, just on that, starting on that score about the African elite, I think we must, sorry.
Yep.
Yes, I think just starting on the African elite, yesterday there was a discussion about calling the judiciary to account, isn't it? Let's not forget that the judiciary, lawyers, and everybody is part of that elite. So we must be careful when we talk about other elite groups and necessarily exclude ourselves. We are part of that elite groups. Even when litigation comes to the judges or to the courts, the decisions are based to some extent on elite interest, not rocking the boat and things like that. But anyway, I have just one question for the panelists. What are we leveraging on? You know, just to talk about independence, it came through struggles in Africa. In other countries, Zimbabwe, Mozambique, South Africa, it came through armed struggle. Now, my question to the panelists is, right, we do our research, we do everything. Are we going to seek to convince them peacefully and say, right, you know, it makes sense to pay reparations? My question is simply, what are we leveraging on? I think we need research. What are we going to use to force, to compel the colonizers to pay? Are we going, for example, I'll just highlight one, are we going as Africa to deny them certain things and say, unless you pay, we are not going to do the following? So I'm simply saying we need to think about that. What are we leveraging on in order to get reparations? Are we just going to beg them to try to convince them for them to see sense? What are we going to depend on? Thank you.
Thank you, Judge. The last one, the lady at the far right.
Thank you, Mr. Chair, for the opportunity. I just wanted to chip in on some of the points regarding the topic. And my very first point is with regard to the experience in Uganda. You just wanted to ask the presenter, how has that been able to change the discourse, the discussions regarding historical injustices in Uganda, the issue of renaming the streets in Uganda from colonial names? What was the willingness of the government in Uganda to accept the move and all that? And what is the current status of those streets in Uganda, the names of the streets in Uganda? My second point is just more of a comment, and I just wanted to follow up, just make a footnote to the last speaker who spoke about the use of the African court in trying to sort of, conceptualizing these issues. While I agree that the African court can be used as one of the mechanisms, but we also know the limitations that are also there with regard to accessing the African court itself. I was just trying to read quickly article, is it Rule 82 of the African Court, which deals with the request for advisory opinion. And it says that a request for an advisory opinion pursuant to Article 4 of the protocol may be filed before the court by a member state, the African Union, or any organ of the African Union, or an African organization recognized by the African Union. And in this particular point, I haven't seen any of the African, what are these, international NGOs with observer status being mentioned here. So that's one of the first limitations that I can find. But again, when you're talking of the member states, how many countries have signed the protocol establishing the African Court? And even if they have signed, how many Africans have accepted the competence of the African Court for it to be able to seize the opportunity to even provide its advisory opinion? So we're just getting back to the same issues to do with states' willingness, to pursue the move itself. My last point is on the database. That's the last question. I just wanted to know, has it set any timelines for its work? I think this was just spoken by one of the very speakers in this topic. Thank you, Mr. Chair.
Thank you very much. Let's come back to the panel. Let me disabuse you from the notion that you have to answer all questions. In the interest of time, you can pick a few, and then we can have conversations along the corridors as the conference continues. So I'll start with Dr. Catherine, and then come this way.
Yeah, thank you. Absolutely, it's working. Thank you very much for this robust discussion. I think one thing we need to really put on the table is that we need nothing less than a movement to achieve any change that we want. So that dynamic has to be on the table. So one of our leveraging points is unity as a continent. All of us 54. Because we are actually victimized as a whole, as a continent. When we talk about Africa, it's looked at that way. Also, we need to conceptualize victimization the way it is. In one of my chapters that I'm contributing to the book on the guiding principles of reparation to Africa, I'm looking at the territory, the African continent, as a victim itself, as a victim. And it's not any different. It's a victim of financial exclusion. It's a victim of proxy wars. You'll be surprised by what is behind all these wars in Sudan, in the Democratic Republic of Congo. If those resources got finished, I don't think we'll have any wars. And it's not any different from what we are seeing in the black populated areas in some white-dominated countries, even Colombia. We visited Colombia, and we found a whole region where black people were. The people who were enslaved were taken to that particular region, which is full of resources. And this part of Colombia has had a war for the last 40 years. And recently, there was a negotiation between government and the so-called rebel leaders. And when the rebel leaders came to the table, these were all white people with their children going to London, to all these big capitals of the world. So who is fighting? When you see the people fighting, you will see only black people fighting. But fighting for whose interests and for who? That is also something. So those systems, those plugins that keep that draw lines of difference and cause Africans and other people to fight themselves for the interests of others and to the exclusion of themselves is exactly also what we are talking about. We have to also repair ourselves from that damage. The extortion, recently I met a young man, he was coming from Liberia, and he says that they load trucks of gold to be put in planes to go to Turkey. We are still having resources running or going out of this continent to other places for no pay. And of course, with some collaborators complicit in that. They have always been there. And those constitute some of the elite class that we see in our continent. So we have come to the conclusion as a working group that poverty is structured. It is a structure, it is a system, it is ordered. What makes African countries pay more interest for the loans they get from the World Bank than the US pays or any other country? Why would African countries pay more? And because these systems are structured, the victimization is structured, the poverty is structured, the impoverishment is structured, we are seeking not less than structured remedies. Structured remedies that address systems, not just individuals and giving goats and cows. That's very good, it's excellent. The people got some mobile phones, but we require structured remedies. Currently, they're calling for a seat at the UN Security Council for Africa, and we're saying, why not? That's where the big decisions are made, and Africa should be on the table. There are 54 states, twice the size of the European Union. 54. European Union has, I think, 22. Thank you.
There was a question on Uganda.
Yes, absolutely. The case was filed in the final weeks of August, so we're waiting for that. Thank you.
All right. Thank you very much for all the powerful questions, some of which we need to discuss over tea break and lunch. I'm definitely going to talk to the good justice here more on effective remedies and how we frame that. So one of the first things I want to respond to in terms of what would an effective remedy be, and also the question about making reparations about cash. It's not just about cash. As we've established, there's also the cultural dispossession that has happened, how our languages have changed. Some of us don't speak our local dialect as well as we speak English or as well as we speak French, right? And so looking at those other forms of reparations, yes, the fund is important because Africa is impoverished. We have a lot more debt, and the Global Fund for Reparations would help alleviate that. Of course, there's an issue of corruption. Having a fund is one thing, and making sure it gets to the right people is another thing, right? But debt cancellation is something that helps, because if we have debts cancelled, then we don't have the continuing effect for generations where our social services infrastructure is not there and we have debts that we're paying internationally. That's one form of reparations. Another one is repatriation of artifacts, like we've said, and how that ties to our cultural heritage. In our curriculum, do we know as African children, as African youths, what happened 100 years ago, 60 years ago, and how that continues to affect us? We see what we call in Nigeria Japa syndrome, which is a lot of Nigerians, West Africans, and across the continent going abroad to live, work, the brain drain, right? It's the idea that it is better, you can succeed or you can make it in life there as opposed to here, because infrastructures do not exist here that helps our dreams flourish. And so when we talk of reparations, how do we move what happened historically that continues to have a contemporary effect on our quality of life, and make sure that it is translated in a way that the young African who exists today, who may not have existed when colonialism and slave trade happens, but feels the effect of it, is elevated from some of those consequences. And so it brings me to the question of who are the victims. The victims are us. The victims are us because it is a continuing violation. The effect did not stop in 1960s when we gained independence. We gained independence with debt, right? We look at the land system, the dispossession of land. I come from Nigeria. We have the southeast part, Biafra, and the war that happened there. We think of different African communities and how the concept of land changed because of colonialism, how the local systems that were established were pushed aside to adopt the British system, for instance, where land was owned by the state or for the people and held in trust for the people by the Queen. And then for us, it's now held in trust by the government or by the president, and you're given a lease for a particular period, as opposed to what existed before, right? And so when you think of land and linking land to a lot of the violations that happen, the conflict that happens on the continent, you can definitely tie colonialism and that injustice to some of the contemporary issues that happen in Africa. Last week, I was at the African Transitional Justice Forum and having this conversation about initially motivated. So we talk of TJ processes, peace building processes, truth and reconciliation commissions, international criminal tribunals, and all of those mechanisms that exist under TJ, but we do not have those same systems expand to cover reparative justice, and that's a conversation we need to have, whether we're building a new framework or expanding the framework that already exists. And so if we link that back to reparations and drawing inspiration from some of those processes, having discussions, commissions that are able to educate Africans on what happened, but also allow people share their stories. There's an angle on patriarchy and women and how women are affected. Of course, women face structural discrimination as women, but also in terms of decision-making processes, some TJ processes that already exist do not include women enough as much as they should. And so going forward, when we talk of the Namibian situation, how do we discuss reparations and make sure that the plights of women are heard? There is ongoing advocacy in Belgium for women whose children were taken from them that were biracial children, right? And so we also definitely need to amplify more the impact of racism, colonialism, transatlantic enslavement, and how that affected women. That's definitely a valid point to be made. Yes, and then I guess the other question about continuing effect and why we should not look at colonialism and slave trade as something that happened in the past and therefore may not necessarily have reparations now is because we see that where there is political will, reparations can happen. It happened for the Jews, it happened for the Japanese Americans. Why can't it happen for Africans? It's a question of political will, and we can help push the political will discussion. When you look at, just a final point, when you look at the implementation of decisions from the African Court, from the African Commission, from the African Children's Committee, it boils down to political will, and we're like, oh, states do not have the resources, states do not know how to engage, but we as civil society are able to push in different circles to make sure things happen, no matter how small. If we apply the same methodology to this international system and to the question of reparations, we will be able to push. The Nuremberg trials showed that former Nazi German officials were tried, even though the crimes were not necessarily established at the time it happened, but the forums were established to try those crimes. Same, like I said, for Japanese Americans. So we cannot say that statute of limitation and it's all in the past, it can't be, we can't receive reparations, because if there's the will, it can happen. And it's for us to push that. Thank you so much.
Thank you. Waikwa, only speak if you can improve on the impressive performance of the female gender of the panel. No, proceed.
Thank you. I just want to address maybe 4 things. First of all, I come from the background of strategic litigation, and one thing that strategic litigation does is to train you about the limitations of the law and litigation. This is not a legal project. This is a political project. The role of law is catalytic. It's not the solution. And judges and lawyers, when they think about what to do about reparations, they can't think that they are the ones who will provide the ultimate solution. They have to think that they will catalyze the conversation, but also help guide what solutions might be, including the question about effective remedy. Ultimately, the political actors will have to do it. But we know that political actors don't want to do it, partly for the elite consensus issues that has been highlighted, partly because of the political politics, foreign policy and such. We know that political actors care little about communities, and this is about community justice. So it's really important to think about it as we think about the question on odious debt, for example, as we think about leveraging, what are we leveraging? It's really thinking about how are we going to leverage the law to help resolve a political issue. And how are we, as judges and lawyers, going to push political elites to do something or to bring justice to communities? The second, effective remedy, and the issue again about elite. Maybe the good judge didn't say 450 million, how much of that went to the lawyers? How much of that went to the community, right? Long-standing, right? What's the long-standing issue? I can't stop quoting Senior Counsel Gitobu. One genius of Mau Mau litigation is beyond having the direct victims, and that was an issue that helped resolve who participated in the litigation. A critical element is that it was carried by a civil society that did not have a direct benefit to the litigation. And so the civil society was able to think about more systemic remedies. And yes, it may not have been enough. In fact, it wasn't. But those are some of the strategies to think about. Because individuals really want compensation, and we can't fault them. They need the money if they can get the money, and they should get the money. But we have to think about it in the long-standing, as it's been indicated. And again, the role of strategic litigation in terms, and judges being able to imagine what might be some of the most far-reaching remedies. The question about Washuka, a question about capitalism. Yes, and thinking about this in the context of money. Yes, but the people who dispossessed thought about it in the context of money. Haiti specifically actually we are talking about being imposed with significant amounts of money that the country has been saddled with for decades. So why shouldn't we think about it in the context of money? Why don't we think about it in the context of unjust enrichment? You go to British Museum or any museum in London, every day, thousands thronging. Yes, they may not be paying to get into the museum, but they're paying to be in London, to go and see Egyptian and Ethiopian mummies. Those people should be going to Addis and Cairo. So I don't think as much as we have to be cautious how we look at it, but I also think we need to tackle the issue about unjust enrichment. In fact, just the last point on this, you know, when you talk about restitution, the people who've been trying to defeat this movement have come up with really interesting terms. They say, but we bring an artifact to African museum. Where? There are no African museum. All the African museum are run down. So they've talked about temporary restitution or loaning African museum their own artifacts. There are two last questions. There are two last points because there were direct questions on the question about the African court. Yes, but actually I think, and I may be mistaken, we have experts in international law, including my friend Dr. Uganda. Pan-African Lawyers Union has the competency to go to the African court on an advisory, and I think one other organization, I'm not sure whether it's the South African Litigation Center, but it's a Southern African organization, but also direct access, even though courts, the nations have been withdrawing from that option. And just for direct, advisory opinion, in fact, Palu has done, I think, 2 cases so far. Finally, justice, to your question on limitations and such, of course, so one of the difficulties of Namibia litigation is you can't invoke the Genocide Convention, because the Genocide Convention, I think it's 1948, the crimes were 1904. So, and that's happening with Haiti, for example, even in the context of what we were talking about, SAD, because of when SAD was established. So there are those challenges. But this is where creativity and court creativity come in. The beauty of Namibia litigation is a course of action was created by the government going and negotiating and coming up with an acceptable whatever. So that is where the course of action lies. And so you are able to actually ventilate issues that maybe couldn't. But also it's what the British court did in the Mau Mau case. Judges have to be bolder sometimes to say these are human rights issues, and maybe to some extent certain aspects of limitation don't apply. Finally, and very finally, experts. The problem with government is they deal with these things while delegations sometimes are not paying sufficient attention and they don't use experts. We can't dismiss the role of experts. And that's the problem with Namibia again. And it's a problem everywhere, actually. The role of experts in quantifying the externalities of the compensation or restitution that's owed to communities. Thank you.
Thank you. Dr. Namakula has an important data point.
Yes, thank you, moderator, for the permission to actually add to what my colleague has already mentioned. I'm reading this from the website of the of State, and it does note that we are pleased to announce that the U.S. received the $335 million U.S. provided by Sudan to compensate the victims of the 1998 bombings of the U.S. embassies in Kenya and Tanzania. So that's the U.S. receiving millions of dollars from Sudan. The question of Haiti that has just been talked about, this was the first black republic, a republic formed by formerly enslaved persons. And this republic fought, the people of Haiti, or slaves, organized themselves and fought off French oppression. So after defeating them, the French, or France, did say that it would not recognize the republic unless they paid to them billions of US dollars for that. And they deployed near that. And Haiti paid for a century because it borrowed money from French banks. And that's why Haiti is the way it is. And so are other African countries.
Thank you. I was an accidental facilitator for this session, but what a happy accident. I've learned a lot. Have we learned a lot? I want to thank you so much. You brought together so many things we've read in the past. Ngugi wa Thiong'o and decolonizing the mind and the politics of language. You've reminded me of the debate between Professor Skip Louis Gates and Mazurui on compensation with respect to the slave trade in the Middle East. You've reminded me of UNESCO African history that was led by Professor Ogot, and many other things. I want to thank the panel for a very good job. Let's give him a round of applause. You will agree with me, and we want to thank AJS for putting us in this cosmos of thought. So significantly reduce on this subject. Thank you very much. Director.
Indeed, we are very, very grateful. Thank you, Duncan, for moderating that session so effectively. I would like now to welcome you to enjoy a break until 12 o'clock, where we will reconvene right here for yet another powerful session, a book launch session on judicial financial independence in Africa. I thank all the panelists and you all for sticking to the time and keeping to our traditions. We did not open with a prayer, and so I want to welcome Boru to commit the break and the day to God, and finally recognize the presence of Chief Justice Emeritus David Maraga, who's joined us. Welcome, my Lord. Please.
Okay, let us pray. I will read the opening surah of the Surah Al-Fatiha of the Quran in English. In the name of Allah, most gracious, most merciful, all praise is due to Allah, the Lord of the worlds, the most compassionate, the most merciful, Master of the day of judgment. You alone we worship, and you alone we ask for help. Guide us to the straight path, the path of those you have blessed, not of those who have incurred your wrath, nor of those who have gone astray. Amen.
Thank you very much. Let us be back here 5 minutes to noon so that we can give back the 3 minutes that we have extended. Thank you very much.
We need to register for the book launch.
Yes, please register outside for the book launch. As you proceed for the break, please register outside for the book launch. See you at 12, 5 minutes to 12.
Cypher Lee in the mix. Turn up the speakers. It's DJ Cypher Lee in the mix. speakers. DJ Cypher Lee in the mix.
Drown out the noise. Listen to the sound of my voice. And just take a second to refuel. 'Cause when you stop worrying about other people, life is kind of peaceful. So come, go through the motions with me. I want you to breathe in and hold it for free. Breathe in. And breathe out. Let go and release. This is your moment of peace.
Turn up the speakers. It's DJ Cypher Lee in the mix.
Thank you. May we take our seats? Thank you. Thank you very much. We'd like to thank all of you for honoring our invitation to attend this launch. In our midst, of course, we have participants that were here from yesterday, participating in the Africa Judges and Jurists Summit. We also have participants that have joined today from academia and civil society. And for the next 1.5 hours, we're going through this program. As you can see on the table, there's a program for this book launch, 1.5 hours. We have introductory remarks. After that, we shall have introduction to the publication that we're about to launch. Then we shall have a keynote remarks of the book. Then a reflection section about issues emerging from the analysis in the book. Then we shall have remarks from the chief guest. And after that, we shall have a photo session, so photos. To start us off, I'm going to invite our director. And as I do that, I'm just waiting for everyone to take their seats. Who is going to lay down the protocol, which I hope the rest of the speakers will do, will follow, will observe. So as I wait for people to sit, I would also like to recognize two of my previous bosses that are present. So Linda Bore at the ICRC and Waiko Wanyoike at Katiba Institute. Thank you for coming. May I now please welcome our director, Dr. Stephanie Rothenberger, our director at Konrad Adenauer Stiftung Rule of Law Program for Sub-Saharan Africa, to formally welcome us. Thank you.
Thank you. Thank you, Ben. Dear Honorable Chief Justice of the Republic of Kenya, Lady Justice Martha Koome, Honorable Chief Justices Emeriti of the Republic of Kenya, David Maraga, Professor Dr. Willy Mutunga, Honorable Chief Justices and Chief Justices Emeriti from across the continent, Honorable Justice Moses Jinhengo, Chairman of AJJF, Honorable Justices, Honorable Vice Chancellor of Kabarak University, Professor Henry Kiplagat, and his delegation from Kabarak, ladies and gentlemen, distinguished guests. I'm pleased and honored to be with you here today and to welcome you to the launch of a, I would say, rather important book. A study of 11 sub-Saharan countries on judicial financial independence in Africa, edited by Dr. Konrad Bozire. Konrad Adenauer Foundation, very briefly, for those of you among us who might not be familiar with us, is a German political foundation who runs over 100 offices worldwide, fostering democracy, good governance, social market economy, peace, and solidarity. Our Rule of Law program for Sub-Saharan Africa, which is a legal program, is just one of these many offices. Since 2006, we have been present in Nairobi, covering Sub-Saharan Africa with our work, with a strong commitment to creating a forum for those on the continent who want to support and further the rule of law. It is therefore not surprising that one of the main pillars of our work is the promotion of constitutionalism, the separation of powers, and of strong and independent judiciaries. We have been very active in this field, implementing various projects, closely cooperating with judiciaries across the region, be it on a national or a regional level. And while we are here in this book launch, just to give you an example, our program is, for example, at the same time co-organizing the tripartite dialogue of regional courts taking place in Arusha. When Konrad Bozire came to me about 2 years ago and shared his ideas about the book, a comparative analysis on judicial financial independence on the continent, I immediately knew that he's bringing something very valuable to us and that he wants to do something absolutely new, but also something that could be a really helpful tool to many. I did some research and I could in fact not find much, or in some cases any information at all on budgetary allocations to the judiciary in African countries. But what I knew for sure, and what I had learned right at the beginning when I came to Kenya 4 years ago, was how the judiciary suffered from budgetary constraints after the annulment of the presidential elections in 2017. At the time, I could only imagine that this was most probably not an isolated case. And out of my discussions with Konrad on the whole topic, our cooperation on this book was born. The need for robust judicial financial independence is not theoretical, but rather a pressing reality across many African nations. Countries in sub-Saharan Africa face tangible challenges such as inadequate funding for judiciaries, political interference in court rulings and judicial appointments, or budget cuts used as a form of manipulation. And I'm well aware that some of those who have suffered severely from these challenges are among us today. Despite these issues, there have, however, also been positive reforms, including constitutional amendments to strengthen financial independence and the establishment of independent bodies to manage judicial finances. Additionally, some courts have actively asserted their financial independence through rulings and advocacy. Chief Justice Emeritus Willy Mutunga put it very rightly when he once stated, "A judiciary that is beholden to the executive or any other arm of government cannot be said to be independent. It is in financial autonomy that true judicial independence is anchored." This truth is at the heart of our work and the focus of the book we are launching today. Judicial financial independence in Africa captures the complexities judiciaries on the continent are grappling with, offering valuable insights and actionable recommendations to address these challenges, providing a unique roadmap for enhancing judicial independence in the region. I thank you, Konrad, that you came to us at CAS to share your unique project idea. Your passion and commitment as the mastermind and editor of this book have been remarkable. And to whomever I talk about the book, I'm immediately captured in a lively discussion, which shows that the book is a timely contribution to a topic of major importance. I would also like to extend my sincere gratitude to the authors of this book from across the continent, namely from Malawi, Nigeria, Zimbabwe, South Africa, Tanzania, Uganda, Kenya, which is Konrad himself, Ghana, Namibia, Zambia, and Botswana, for their in-depth analysis of legal frameworks, financial structures, and practical challenges that influence judicial financial autonomy in their respective countries. I'm happy that at least some of the authors can be with us today, and of our distinguished paper reviewers. I thank you for your high-quality work, ensuring that this publication meets the highest standards of scholarship. In addition, I would like to thank Kabarak University Press for their role in publishing this important work, and of course, the AJJF, namely Honorable Justices Moses Chinhengo and Isaac Lenaola, together with the Secretary General of AJJF, Martin Masiga, who made it possible for us with their team to launch the book during the first All-African Judges and Jurists Summit. It is an honor for us as Konrad Adenauer Foundation that you have created a space for us in this excellent forum. But before every one of you can hold this book in their hands, we have put an interesting program together for you. I'm proud and honored that Honorable CJ Emeritus David Maraga, who also wrote the foreword to the book, will give keynote remarks on the book, that we will have reflections by a panel of high-ranking judges from across the region, and that Honorable CJ Martha Kome will officially launch the book. My deepest gratitude to all of you for making the launch of this book a memorable event. A book that is not merely an academic achievement. It is a crucial tool in our shared endeavor to secure the independence of judiciaries across Africa. It is the expression of a collective commitment to the rule of law, justice, and the protection of human rights on the continent. Thank you. I would now like to invite Honorable Justice Moses Chinhengo, Chairman of AJJF, to the stage.
The Honorable Chief Justice of the Republic of Kenya, members of the Judicial Elders Council of the AJJF, and the Director of the Rule of Law Program for Sub-Saharan Africa, who has just given a speech. Thank you very much for your remarks. I will just take a very brief overview of the book, testimony to what African jurists can do. Well, the first point I would want to make is that in the keynote speech by the CJ yesterday, one of the issues she highlighted was the financial independence of the judiciaries in Africa. And this book, of course, seeks to answer that question as well. So while the general principle of judicial independence has been a subject of scholarly and policy attention over many years, the subject of judicial financial independence, and specifically the mechanisms of it, has not received equal attention. This book explores the frameworks, policies, and practices of financing and resourcing judiciaries in Africa, and the relation of the country's practices to the pillars of judicial independence. Using the 11 countries, the 11 country case studies covered in the book, Kenya, Zimbabwe, South Africa, Uganda, Tanzania, Malawi, Botswana, Zambia, Nigeria, Ghana, and Namibia. The book explores different aspects of judicial financial independence. These include recognition and entrenchment of judicial financial independence in normative frameworks, the process of determination of resource needs for judiciaries, approval of budgets, control and management of resources allocated to the judiciary, and accountability and reporting on the utilization of resources allocated to the judiciary. The chapters in the book demonstrate a complex relationship between financial independence and effective administration of justice. The introduction and concluding sections of the book draw common and unique trends in the 11 countries in the themes identified. These include the different approaches to budgeting, control and management of resources, and the institutional mechanism for funding judiciaries. This is followed by and concluding observations on specific themes. The main objective of the book is to stimulate discussion on how to enhance the financial independence and autonomy of the courts and judiciaries in the region. Through this publication, we hope to spark a broader conversation that includes not only the judiciary in one country, but also other judiciaries across the continent, policymakers and stakeholders committed to strengthening the rule of law. I think it is an important subject, and of course we will hear more detail about the book in due course. With these short remarks, may I thank you all for attending this launch. Thank you very much.
Thank you, Justice. I would now like to invite the Vice Chancellor, Kabarak University, Professor Henry Kiplagat, to make his introductory remarks on the launch. Welcome.
Retired Chief Justice of the Republic of Kenya, Honorable Chief Justice Emeritus, Othman Chande, Retired Chief Justice of the United Republic of Tanzania, Honorable Chief Justice Emeritus Andrew Nyirenda, Retired Chief Justice of the Republic of Malawi, Honorable Chief Justice Emeritus Professor Willy Mutunga, the Retired Chief Justice of the Republic of Kenya, Honorable Justice Moses Jinhengo, Retired Chair of the Africa Judges and Jurists Forum, Honorable Senior Judges present, Dr. Stephanie Rothenberger, Konrad Adenauer Foundation's Director for the Rule of Law Program in Sub-Saharan Africa, Professor Ochola, the Deputy Vice Chancellor, Kabarak University in charge of Academic and Research, Professor Ronald Chipkilot, the DVC, Kabarak University in charge of Administration and Finance, Dr. Conrad Bosire and authors present, distinguished guests, ladies and gentlemen, good afternoon. It is with great pleasure and honor that I join you here today to celebrate a significant milestone in legal scholarship and judicial reform. The launch of the book, Judicial Financial Independence in Africa, a study of 11 sub-Saharan countries, marks a pivotal moment in the pursuit of a fair and equitable legal system across the African continent and in comparative constitutional studies in the world over. This remarkable publication, conceived by Dr. Konrad Bosire, was who inspired and directed the excellent team of authors supported by Konrad Adenauer Foundation and proudly published by Kabarak University Press, stands as a testament to Kabarak University's commitment to advancing the academy in Africa and fostering insightful dialogue in critical issues such as judicial financial independence. Distinguished ladies and gentlemen, at Kabarak University we are dedicated to the pursuit of excellence in research, scholarship, and innovation. Our vision is not only to produce knowledge for knowledge's sake, but to actively contribute to the betterment of African societies through rigorous inquiry and informed discourse. Therefore, this publication is a reflection of our collective dedication to nurturing a judiciary that is strong and independent, capable of upholding the rule of law and safeguarding the rights of all individuals. The book, Judicial Financial Independence in Africa, a study of 11 sub-Saharan countries, presents a comprehensive analysis of the current landscape and recent advancements in judicial financial independence in the diverse 11 African countries. By analyzing the intricacies of budget allocations for the judiciary, interrogating the administrative processes that either restrict or enhance judicial autonomy from executive and parliamentary interference, and examining their tangible effects on institutional and individual decision is also timely, as Kabarak University School of Law is poised to launch in the coming year the first of its kind postgraduate program in judicial sciences in Africa. A collaborative effort with the Kenya Judicial Academy, to which we owe our gratitude to Honorable Chief Justice Martha Koome for our support, and Cardiff University in the United Kingdom. Kabarak University is committed to advancing the African study of comprehensive constitutionalism, and more so, the particular study of the judicial sciences, which is a critical but undeserved sub-branch of constitutional studies across the globe. This outstanding text will take its pride of place in the core texts that will advance such studies not only at Kabarak University, the Kenyan Judicial Academy, and Cardiff University, but I believe also in the judicial training institutes and law faculties in the various countries represented here today, and across the legal and political sciences academy across the globe. Distinguished ladies and gentlemen, I must say, I'm also proud to be here with our senior member of faculty at the Kabarak University School of Law, Professor Willie Mutunga, retired Chief Justice of Kenya, and the Honorable David Maraga, retired Chief Justice of Kenya, and the 2023 recipient of the degree of Doctor of Laws honoris causa at Kabarak University. With such senior intellectuals and practitioners of law, I am very confident in the bright future of Kabarak University. I thank our partners, Konrad Adenauer Stiftung, Rule of Law Program in Sub-Saharan Africa, and to Dr. Konrad Bosira for inviting us to this excellent scholarship and publication journey. I look forward to many more similar and fruitful collaborations. Finally, distinguished men, I would like to take this moment to thank our gracious hosts, the African Jurists and Judges Forum, and to welcome you to Kabarak University. We would be honored to host you as graciously as you have hosted us in a serene academic setting in the unique ambience of Kabarak University. I thank you.
Thank you very much. That is the end of the introductory remarks. We now move to the content of the publication, and I would like to invite the editor, who is also the author of 3 chapters, Dr. Konrad Bosire, and Lungoe Matakala, who is one of the authors. Up front to make introduction remarks, brief introductory remarks, and Konrad will do a bit more.
Thank you very much, Ben, for the invitation. And kindly allow me to ride on the protocols that were earlier very ably established because of time. Good afternoon. Thank you very much for honoring our invitation to be here today. My name is Konrad Bosire, but please make a distinction between the two Konrads, just in case you have ideas like mine and you need some money to implement. Please go to the right Konrad. Yeah, thank you. So maybe before I make my short remarks on this book, I just want to recognize the team that is here with us that led to the publication that we are doing today. And maybe I would invite my co-authors, including Dr. Lungoe Matakala, who is about to speak after me, then to stand where they are, and I will introduce them. Please, the authors here present, kindly stand up where you are. We can... Thank you. Thank you very much. Believe it or not, some of the faces, actually most of the faces you're seeing here, I also saw them this morning for the very first time. But just to add that our inboxes are very familiar with each other. So we have Dr. Lungoe Matakala. She authored the Zambian chapter. Thank you very much. There we have Benjamin Mbekezeli from South Africa, together with 3 other co-authors, did the South African chapter. Thank you very much. Then we have Dr. Ruhweza Daniel from Uganda, Makerere University School of Law, did the Ugandan chapter. This is Onalethata Kambai. I'm seeing him for the first time. He did the Botswana chapter. Thank you very much. We have here Dr. Grace from Tanzania, the Tanzanian chapter. Thank you very much. And then we have Professor Teresa Akpogome from Nigeria, the Nigerian chapter. Thank you very much. You can please have your seats. We have other authors who could not manage to join us today. As you've heard, it's 11 countries. There's Kenya, Tanzania, Uganda, Zambia, Nigeria, Ghana, Namibia, South Africa, Zimbabwe, Botswana, and Malawi. Malawi, we had Professor Muizankata. He's actually in Nairobi, but is attending to some other very urgent business. He was actually supposed to be here to make remarks, but he excused himself. But he is around, and of course, together, the 11 of us were able to produce these books. Thank you very much. Just very briefly, in the next 2 minutes, to speak about the inspiration behind this book. From 1st of May 2018 to 12th January 2021, I was the Chief of Staff for the Kenya Judiciary, working and heading the Executive Office of the Chief Justice, CJ Emeritus David Maraga. During that time, we had a lot of concrete discussions on the planning, budgeting, and execution accountability of judiciary finances. But with time, I realized what we were doing in practice has actually no relation with the literature I read on judicial independence. And this is backed up by the post-27 challenges that the judiciary experienced. And I thought that maybe this could be a good area for research. I do not want to go into the specifics because there will be more speakers here, very distinguished, talking about various themes of the book. But very briefly, just to mention also that generally, a lot of court decisions are analyzed, quoted, and waited for with bated breath by people in search of footnotes like me. So we have judges who have to be careful what they write, otherwise they'll be criticized in journals and all that. But as Duncan Okello, my predecessor, usually says, he's somewhere in the room, that the judiciary as an institution, leave alone the judicial decisions, is rarely studied. How it operates, how it works, the objectives, and how it leads to effective administration of justice, and especially the topics such as the book here, are rarely studied, and that is why many people are saying that what we are reading here perhaps is one of the first pioneering studies. So that was the broad inspiration to do this. But as I dug deeper into the research, I actually find that it's not necessarily a very new question. If you look at ICJ conferences In the late and mid-80s, in Zambia, in the Gambia, they talked about judicial independence, and even Kenyan judges back then participated in those meetings. I saw the workshop proceedings. But I think the political environment at that time did not allow the scale of discussions regarding judicial independence generally to flourish beyond those discussions, and maybe now we have the space to do that. So here we have looked at, of course, the 11 countries, Anglophone, sub-Saharan countries, and as we say in research, we'll start with the known and move to Francophone and all of Africa and see how similar questions are answered. But just 3 things. The colonial baggage and how it affects judiciary finances, centralization of the judiciary, governance, the fusion of judicial power together with colonial governance power, magistrates acting as revenue collectors and as district administrators. That is an example of that. Then the judicial subjugation that followed post-independence, and of course, the centralized public finance management systems that we have in the post-colonial system and how they have affected. How that affects budgeting and planning, management of finances, and accounting and accountability and reporting by the judiciary, and the role that the political arms of governments play in those technical processes, and how all this affects judicial independence generally is what the book is about. And what needs to change, I think part of it is covered in the book, but I believe this will spark a broader conversation. As I finish, I just want to thank very wholeheartedly Konrad Adenauer Stiftung Foundation, Dr. Stephanie Rothenberger, and the team at CAS for the facilitation to have this publication come to life today. I also want to thank Professor Kiplagat and the team at Kabarak University for this, the wonderful publication that we are just about to launch, and within very strict timelines, producing such a wonderful text. I don't want to speak more. I know more speakers will say something about the book in more specific themes, so I would love to drop it there and maybe give my colleague Lulu 2-3 minutes before we proceed. Thank you very much, and again, thank you for honoring our invitation to be here. Thank you.
Distinguished guests, with your permission, may I please ride upon the protocols that have already been observed and ably established. My name is Lungowe Matakala. I teach law at the University of Zambia, and I am one of the 11 authors in this publication. I'm going to share with you my experience as well as my expectation. What was my experience over the 2 years that we roared together to come up with this publication? Allow me to use an analogy. When a woman who has been trying for a long time to have a child finally conceives, there is no greater day in her life than that day. There's a lot of excitement. But you know, the 9 months that follow are not necessarily filled with excitement. There's morning sickness, swollen feet, you know. Then comes the big day when she has the baby. It starts with pain, trauma, but ends with a beautiful bundle of joy in her hands. That was my experience. The invitation, when it came, I was so excited. Then started the data collection, and I couldn't get information on the judiciary. I went through all the protocols. But to get that information, oh my God, it was a challenge. At some point, I even wrote to Conrad and I said, I think I'm getting off this train, eh? You know, and Conrad said, no, we're almost there, let's continue. And voila, we're here today. What a great joy it is for us as the authors. What a great joy it is for CAS. What is my expectation? Allow me to use an example of a study that I recently undertook. Zambia conducted its second audit of prisons starting in 2022, and the report was finally launched in 2023. The audit of the prisons was commissioned by the Minister of Justice as well as the Minister of Home Affairs. And I had the rare privilege to lead the research team. Our greatest finding, overcrowding. Prisons that have a capacity to hold 10,000 were holding more than 23,000. Inmates sleeping like sardines. Poor health conditions in there. No human dignity. Inadequate access to drinking water, toilets, you name it. What does that have to do with the judiciary? Well, among all the institutions that play a role in the criminal justice system, our findings showed that the judiciary was the one contributing the most to the problem of overcrowding. More than 1/5 of the inmates in Zambian prisons are remandees awaiting trial. And then we have inadequate court spaces, judges being moved, missing files. In short, a lot of people are unable to access justice. And yet there's something we can do about that. And so I thought that as we launch this powerful book, if I may call it that, that it would be appropriate to share these gloomy realities on the ground and to challenge you and say, what are we going to do given this kind of information? Research is not undertaken just for the sake of. We have findings that are supposed to lead to action. And so as this great book is being launched before this august house, may I humbly appeal to all of Africa that is represented here, that indeed this publication is going to play a role in pivoting judiciaries for the transformation of Africa. I thank you.
Thank you very much, Dr. Lungawe. I can confirm for those emails that I was copied that sometimes Conrad and I could joke that if we were to compile the emails into a publication, it will probably be a bigger volume than the volume that we are about to launch. So it's been a long journey. So the next session is now for the keynote remarks. The Honorable Chief Justice Emeritus David Maraga, also as was mentioned, did the forward. And so I would like to make the keynote address. Thank you.
The Honorable the Chief Justice of the Republic of Kenya, Justice Martha Koome, oral protocols observed. Ladies and gentlemen, good afternoon. I trust that we are all enjoying this summit with many presentations that have been made, very, very powerful and very, very enlightening in various aspects of law. I take this opportunity to, as a Kenyan, to welcome our visitors to our country. Join hands with those who have already welcomed you, and I trust that your stay here, though short, is going to be memorable. I'm glad and indeed privileged to give remarks on the book that we are about to launch, Judicial Financial Independence in Africa, a study of, as you have been told, of 11 sub-Saharan countries. As you all know, a subject of resource and financial autonomy of the judiciary bears great significance to the effectiveness and the workings of the judiciary. I believe that the book that we are launching today is one of the first studies on the subject of judicial financial independence in the African region. I therefore wish to sincerely congratulate Dr. Conrad Bosire and the other authors, as well as CAS, Rule of Law Program in Africa, for this great initiative. There is no doubt that the book will steer an important conversation in the region regarding one of the most critical aspects of institutional independence of the judiciaries. How judiciaries plan and manage their finances and the nature of the roles that the other arms of government play, and as well as external agencies, in the planning and management of the resources allocated to the judiciary as a critical bearing on both the independence, the operations, and the efficiency, as well as the effectiveness of the judiciary. In a broad summary, how the law, policies, and practices facilitate the judiciary's determination of its priorities, which priorities are funded, and the manner of funding can limit or enhance the independence of the judiciary. Judicial financial independence generally refers to the institutional arrangements, rules, structures, and processes put in place to ensure that the determination and the priorities of the judiciary, including the terms and conditions of service of the judges and the judiciary staff, access to funds available to the judiciary, and how the management of those funds is safeguarded, especially from the executive arm of government, is critical. Of course, this would also include the manner in which the judiciary is transparent and accountable in the way it manages and uses the resources allocated to it. The book we are about to launch provides us with analysis of the status of the judicial financial independence in Africa, looking at the framework and the practice in 11 countries which have already been named: Kenya, South Africa, Zimbabwe, Malawi, Uganda, Nigeria, Botswana, Tanzania, Zambia, Ghana, and Nigeria. Through the specific experiences of these 11 countries, the book covers themes such as the recognition and entrenchment of principles of judicial financial independence in the constitutional and legal frameworks, budgeting processes for the judiciary, the management and the control of the resources allocated to the judiciary, and the accountability and transparency in the management and the utilization of funds in the hands of the judiciaries, among other issues. The book thus paints a landscape of the recognition, entrenchment, and the practice of judicial financial independence in the African region. The book deals with some major themes and issues which cut across the 11 countries, whose experiences it details, and which I want to briefly highlight. First, as it has already been pointed out, colonial governments and its persistent culture in the post-colonial structures of governance still impacts heavily on the manner in which judiciaries are structured, funded, and facilitated. Specifically, executive dominance in the judicial governance structures, including funding and administration, can be traced to the manner in which the colonial judiciary was designed to be subordinate to the executive. Despite clear constitutional provisions the transition from the colonial culture to one where the judiciary is truly independent has been slow and in some cases uncertain. Secondly, post-colonial regimes have tended to preserve and even enhance the culture of executive dominance and the subjugation of the judiciary for their own interests. This has manifested in the form of resistance to any progressive judicial reforms that have been initiated in the post-colonial era. Specific examples include the release of financial controls from the Treasury, Ministries of Finance, to corresponding administrative units in the judiciary, the linking of staff from the mainstream public service to judicial services, and the enactment of the frameworks and the policies to support the transformation of the judicial independence. These processes will typically attract the attention of the executive and some senior officers in the legislature who have, to a large extent, frustrated the processes. In Kenya, for example, while the Constitution was promulgated in August 2010 and provides for a separate budgeting process for the judiciary, the pre-2010 processes persisted well into the current constitutional dispensation. It was not until I experienced that myself in the office and realized that the financial staff in the judiciary were beholden to the executive. They were taking all their requests and budget requirements to the Treasury. I sat down with them and we went through the Public Financial Act and asked them where is the process. The Constitution requires you to present the budgetary estimates to Parliament, not to the Treasury. And it was a tug of war, but eventually I was able to convince them. And after that, we are talking about 2020. After that, the budget estimates are now presented directly to Parliament. But challenges still remain. ZJ Kome, it took us a lot of effort. Sometimes even we quarreled with some other officers to get just a judiciary fund account opened in the central bank. That's how it is. But this is not a problem that is limited to Kenya only. I was privileged to attend the South African Judges Conference last December, and it took almost a whole day. The discussion on judicial financial independence took almost the whole day. The review of the book findings regarding the amount of resources that are allocated to the judiciaries in the region show a great mismatch between the resource requirements and the actual resources allocated to the judiciary. Except for countries, for two countries, that's Nigeria and Uganda, whose judiciaries get at least 2% of their respective national budgets, the rest of the judiciaries covered in the book get an average of 1%. I was told quite a number get much less than that of their respective national budgets. While the levels of development and the sizes of the judiciaries and other parameters may differ, there appears to be generally a dismal funding of the courts and the judiciaries in the region. It is in this regard, as the book notes, that some judiciaries, such as Malawian and Kenyan, have called for a minimum percentage share of 2.5% and 3% respectively of their national budgets. Fourthly, even the manner in which the resources are planned, budgeted, and controlled differs across the countries is studied and has a definite impact on the independence and the effectiveness of the judiciaries. The approaches vary from resources wholly or partially controlled by judiciaries and those which are freely given. In some countries, for example, Kenya, Uganda, and Tanzania, the law establishes the judiciary fund to manage the allocated resources, while in other countries like South Africa and Namibia, significant portions of the judiciary budget are resident in the ministries. The impact of these arrangements and the financial and the judicial independence differs quite greatly. The establishment of the judiciary fund, for example, under the Kenyan Constitution, the Constitution provides that as soon as Parliament passes the judiciary budget, the entire sum is supposed to be deposited in the judiciary fund, to be managed by the judiciary, and of course, audited by the Auditor General. But that is something we have fought, and just Gome, you are in for a long haul. They will not allow that. My information is that the current budget of the judiciary, Kenyan judiciary, is less than 1%. Out of more than 4 trillion shillings of the budget, you can imagine 1%. It's changed. If the government wanted, it could deposit the whole sum in the judiciary fund account and leave the judiciary to go on with its plans. Come some of the challenges that are created by other arms of government that call in for budget cuts. The judiciary is the first one to be affected. When I was in the office, there was a time it was said that there was going to be, 50% budget cut in most institutions. And we had lined up a program to digitize the judiciary records. And we needed a lot of money. There was 400 million shillings in the account for that purpose. The entire sum was taken. Not even half, the entire sum was taken. And you know what, that I was helped later by development partners to even start that program, which just Gome now perfected, and it's working very well. Ladies and gentlemen, the issue of financial autonomy of the judiciaries will continue haunting the judiciary administration. Not because the country can't afford it. Not because, forget about the limited resources that are there. The reason simply, as I understand it myself, is for the executive to control the judiciary. It's for the executive to control the judiciary. And that is going to be there. As I said, it is not only in Kenya, it is not only in Africa. In fact, in conferences I attended, I realized that it is there in very many other countries, except the Western countries, which are very established. So, in short, even without completing the remarks of this great book, ladies and gentlemen, this book brings to the fore the challenges the judiciaries are experiencing on the continent of Africa. And it invites discussions that should be taken beyond this forum, so that we all come together and see how the judiciaries can be funded so that they are able to discharge their services. I know it as a fact that before these budget cuts came in, the judiciary had advertised for recruitment of several judges. That is in the Kenyan judiciary. When the budget cuts came, that had to be put on hold. And at the end of the day, we are suffering. It is the members of the public who seek the services of the judiciary for them to be helped. I want to stop there. Once again, ladies and gentlemen, I want to congratulate CAS, led by Dr. Stephen Rothenberg, for the excellent work that your program is doing, Dr. Conrad Bosire and your co-authors, as well as Kabarak University Press for the excellent work done in producing this excellent book. Thank you very much for listening to me.
Thank you very much. So one of my roles today is also to ensure that we keep time, like in the next sessions especially. And I suspect Dr. Justice Mavedzenge may start looking at me after some time. And we still have 3 sessions. The next session is 30 minutes. And then, of course, we have 10 and 10 more minutes. We shall do our best. I'll request we do our best with the time in the next sessions. The next session is the reflections on the publication. It will be moderated by Dr. Conrad Bosire. The title might be a little bit misleading because it's not really critiquing the book. Conrad will expound on what it will focus on. But I would like to invite Dr. Conrad Bosire to come to the stage. Then I would also like to invite distinguished panelists. The first one is the Honorable Retired Chief Justice Andrew Nyirenda. The second one is the Honorable Retired Chief Justice Matilda Tome. Honorable Justice Charles Hungwe, who is also Chair of the Judicial Action Group Africa chapter. Lastly, Honorable Retired Vice President of Constitutional Court, Marcelina Gibeha Afauda. Thank you. As they come, many of you may know that one of the less popular words in Kenya is launch. And we are here to do exactly that, to launch. And the dictionary definition of launch is to set in motion. I hope that we may give a better meaning to this term, and do exactly that. Thank you, Conrad.
Thank you very much once again, Ben, for the opportunity and for calling up our distinguished panel of book reviewers. First is to thank you for kindly accepting to go through the book and for coming to speak about it. And you've heard we are pressed for time, so I will not take any more time. Just to welcome the panelists who have been introduced to you with around 30 minutes, but maybe if we can do it in a lesser time, maybe 20, 25 minutes, then we'll be able to catch up with the program. So I will give each panelist maybe 5-6 minutes to reflect briefly on the book as we move with the session. So first to reflect, I'll just go with the program that we have before us. I invite Honorable Retired Chief Justice Andrew Nyirenda for your remarks. Welcome.
Thank you. Thank you so much, Dr. Bosire. My lady, the Chief Justice, I think in absentia, she's just walked out. my lords, distinguished colleagues, I'll be ashamed, terribly ashamed, because we are sitting together with Chief Justice Maraga and listening to what he has just said. It is as if we continued sitting together the whole night. What he has gone through and what he has said is exactly the path that my presentation was going to take. And therefore, allow me to endorse what the Honorable the Chief Justice has said as being the main inroads of the book that we're launching this afternoon. Allow me to start as follows. This book is indeed a study, a comparative study on financial independence, and let me add, financial autonomy of judiciaries in several countries in Africa. Number two, the mainstay of the study is to underscore the fact that financial independence and financial autonomy are critical to judicial independence. Number three, the study unveils the diversity of approaches in the jurisdictions that were studied in financing judiciaries. Number four, what comes out to the fore are the following findings. A, that none of the judiciaries under study are adequately financed or resourced. B, to that extent, and except for one or two countries, even in instances where the judiciaries are financed, the judiciaries are not able to access the resources that are allocated to them. So you have money on paper, you have allocations on paper, but it's a different story when it comes to disbursement. That as a result of the above two factors, judiciaries are constrained to determine their own needs and consequently their operations. The study then looks at some of the factors that make it difficult for judiciaries to achieve financial independence and financial autonomy. And this is where you now notice that I catch up with Chief Justice retired Maraga. History compels us to follow the footsteps of our colonial masters, which still linger in to some extent, where judiciaries are still thought to be an appendage of the central government administration. And that is mostly reflected in the context of judicial administration, where in some instances, I'm not very sure about, I was looking very, very closely to 2-3 jurisdictions. In certain instances, employees of the judiciary, especially the tip staff, are still considered to be part of the executive. I can confirm that in the situation with Malawi. To some extent, I was able to see those dots in the judiciary of Kenya. I was able to see that in the judiciaries of Zambia. So you have the tip staff that respond to the executive. And then what is also something worth noting is the fact that even the appointment of judicial officers is by the executive. In almost all the judiciaries, except 1 or 2, the appointment of judges is by the head of state. Our commissions will recommend, but ultimately the decision is in the hands of the head of state. The appointment of the Chief Justice has to be prompted by the head of state, although it ends up in Parliament. But the initial discretion to appoint a Chief Justice lies solely with the head of state. Most critically, it is reflected, I beg your pardon, most critically, it is reflected in the process of resource allocation. Again, I will not go into any detail that I wanted to share with you, because Chief Justice Maraga has dwelt on that to some extent. What is true for most of our judiciaries is that the process of resource allocation is never with the judiciary. Yes, we can prepare our budgets. Yes, we can be ambitious on paper. But those budgets, those proposals, must end up with the executive. They will give us ceilings. And those ceilings will end up with a committee of parliament. A number of judiciaries, a number of jurisdictions, what will then happen is that judicial officers, together with their administration, will be talking to the executive. They will be talking to committees of parliament in an attempt to defend their budgets. You know what that means? You are appearing before the principal secretaries of government, and you are appearing before parliamentarians, and what that says to you, you are subservient to these entities. That is obviously a very weak link. Now, having said what I have said, let me isolate one critical issue. And again, I beg your pardon, this is an issue that has come through the conversation that we have had with Chief Justice Maraga. And this observation resonates over and over and over in the book. It is about political will. Yesterday, I raised a question here, and the answers that I got were mixed. My question was, how do we relate with the politicians? How close can we be to the politicians? The answers were, keep your distance if you can. And some answers were, don't even dare. And that is our position. And yet, we are talking about lack of political will. The question that I have, and this is the main question in my intervention in this, with this book, what shall we do as a judiciary? And I dare say, Doctor, I read the bit of the book that you sent to me. I was constrained to find a clear suggestion as regards what we should do in order to captivate political will. What shall we do? Stand off? They keep their distance. They keep their corner. They are the deciding factor. We decide to keep our corner. I'll share two experiences, and these experiences shall tell a story. And probably there is more into those stories than the story itself. People like to listen to stories, and once you have listened to a story, it stays with you. It is this. Once upon a time, in the political landscape of my country, when we moved from one-party system to multi-party, we were all very excited. We had an attorney general, a very good lawyer, very professional, long-term experience. He is appointed attorney general. And we all were excited, just as anybody will be excited, because you have an attorney general. And it is through the attorney general that the budget for the judiciary is defended in parliament. And that's the development in a number of countries. Just before the first session of parliament of the tenure of this Attorney General and Minister for Justice, a couple of decisions that did not support government were made. When the budget for the judiciary was floated in parliament, And I remember listening to that debate in Parliament. The first person to wake up was the Attorney General and Minister for Justice himself. And he says, look, what do you expect from these barefoot judges? I quote that expression, barefoot judges. Why should we be here worried about raising money for the judiciary when you have barefoot judges? And this is coming from a minister who is supposed to be defending your budget in the August House. A few years later, in another government, another minister with senior counsel, again, events where that prior to that, there were so many decisions. There will be so many decisions who disagree with government. The judiciary budget is floated. He wakes up and says, because he is asked, Attorney General, Minister, can you give us a guide on this budget? He said, and I quote, you know, I am worried because we are here to talk about a budget of a child who bites the finger that feeds him. Now, when you get into a situation of that nature, honestly, it's a cause for concern. These are not just ordinary politicians, they are lawyers, one or two of your own. Now, if you can get that from lawyers in Parliament who are supposed to be defending your budget, what are you going to get from the rest of the politicians? The question remains, what shall we do and how can we manage this standoff between the political entity and the judiciary? I wish I had some answers to that. Thank you so much.
Thank you very much, CJ Emeritus, for those very insightful words. Sorry, after the 400 and so pages, you didn't get the answer that you are looking for, but maybe it will open up this kind of discussion. So I would like to invite the next speaker, retired Chief Justice Mathilda Tumi Goods, to make her brief remarks. Please keep watching me. If I start shifting uncomfortably on my seat, maybe we are running out of time, so that we can keep within the time. Thank you very much. You're welcome.
Chief Justice Martha Koome, colleagues, Conrad, you can rest assured I shall be very brief. Thank you. I'm very grateful to the authors for sending me a PDF of the book, which I'm a fast reader. I read quite avidly. And I had palpitations because it brought back some very bad memories when I was Chief Justice. I remember having to do 101 on PPBs. Anybody familiar with that term? Performance-based budgets? Yes. Seychelles borrowed lots of money from the World Bank and the IMF. And to balance its budget, all government departments were asked that when they produce their budgets, they have to I don't know whether you've seen the spreadsheets involved for PPBs. You need a PhD just for that. But my experience with that it was impossible to work with. Some of the questions asked, for example, Seychelles has jury trials for murders. They would ask me, how many murders are you going to have next year? You're supposed to put that in a little box so that they can plan how much money to give you if you need a jury trial. Okay? It is these types of impracticalities that made my life very difficult. Okay? And I'm sure some of you know what I'm talking about. So this book has a lot of resonances with me. Seychelles is not one of the 11 countries studied, but the experiences described in this book in terms of the 11 countries are very similar to my experiences. So I have 8 reflections that I take from the book. First, that judicial financial independence and autonomy are essential for effective judiciaries and a separation of powers, but practices across Africa reveal inconsistencies and many contradictions. The evolution of judicial independence in Africa, as has been explained already, diverged significantly from its Western origins, as colonial-era courts were subordinate to executive authority rather than independent entities. Post-colonial leaders often resisted establishing truly independent judiciaries. 3, recent political reforms in Africa have strengthened the role of judiciaries, with courts gaining broader constitutional powers to review government actions. However, this growing assertiveness provokes political reprisals. 4, international and regional instruments emphasize the importance of judicial financial autonomy, but practices in African countries show a very heavy reliance on the executive and legislative branches for budgeting and resource allocation, which undermines judicial independence. 5th, countries exhibit significant variations in the judiciary's role in financial matters, budgeting processes, and resource allocation, with some maintaining more independent judicial budgets while others integrate them with executive departments. 6, judicial remuneration practices vary, with some countries relying on independent commissions, while others give the president or parliament control over judicial salaries, potentially compromising financial security and dignity. 7th, and I think Chief Justice Maraga, retired, talked about this one. Judicial funding trends across the 11 studied countries range from declining to incremental, but overall, judicial budgets remain minimal, often less than 1% of national budgets, and that is the most shocking thing about this book. 8, accountability issues such as the lack of transparency in budget reporting and management of judiciary-generated funds undermine the effective realization of judicial financial independence. So in summary, colleagues, the significant gaps between the recognized principles of judicial financial independence and the realities on the ground in many African countries underscore the need for ongoing reforms and safeguards to strengthen this critical aspect of judicial independence. My colleague here asked, what can we do? I'll tell you what I did, and I wasn't very popular. One of my final years as Chief Justice, in great frustration, I asked the registrar of the court, did we have a key for the judiciary? She said, what do you mean? I said, I need a key, some kind of a key. Give me a key, find me a ceremonial key. And I invited my judges to accompany me to State House. And we went up and we told the president, here is your key. See if you can find somebody to run the judiciary with the budget you've given us. Okay? What else can we do? We did not have money to run anything in the courthouse. And I think the president at the time did get the message. And he proceeded to come to the court. For the first time, we had a member of the executive visiting the courthouse. And you know what the staff of the judiciary were trying to do overnight? They were trying to, the judicial officers and members of the staff were trying to tidy up and paint the walls. I said, leave it the way it is. Why are you trying? We're trying to make it pretty for the presidential visit. Okay, so I said, leave it the way it is. And he came and he saw for the first time. We showed him the case administration system. We showed him all the toilets that were not working. We showed him the registry. We showed him the files falling out of cabinets. And that, it didn't last long, but at least we got the budget that year. A little improvement. Thank you.
Thank you very much, Chief Justice, for those remarks and for sharing the Seychellois experience. Very, very interesting. I wish we had the 12th chapter on that. So now I call upon Justice Charles Hungwe to make his brief remarks. Welcome.
My Lady, Honorable Chief Justice of the Republic of Kenya, Madam Koome, please kindly allow me to ride on the protocols already observed by the previous speakers. Speaking after former Chief Justice is not very easy, but I'll try to make a very brief presentation on the book titled Judicial Independence in Africa. Having been sent the soft copy, I was able to go through each and every chapter to understand what the book was all about. But the authors delve into the complexities of how financial independence can undermine the integrity and effectiveness of judicial systems in various African nations. When I got the book, I had no idea that it was a compilation of by various authors, but I was impressed by the contents and the depth of the research and the analytical tools adopted in dissecting the various judicial financial systems in the 11 countries that were under study. The book begins by outlining the foundational principles of judicial independence, emphasizing that without adequate financial resources, courts may struggle to operate impartially. The book uses a comparative approach, drawing on case studies from the selected countries, which illustrates the diverse challenges each country faces regarding judicial funding and autonomy. One of the outstanding features of the book is the thorough analysis of the legal frameworks governing judicial financing in the selected countries. The authors of the book highlight both the successes and failures, providing a balanced view of the progress made and the obstacles that hinder judicial independence. As previously indicated by other speakers, there have been improvement in the legal frameworks under which judicial funding is set out in the constitutions. There are surprising results, however, that despite the existence of those frameworks, the executive generally and throughout this, the study have not complied even with their own constitutional provisions. And what surprised me most was that there's been no legal action except in one or two countries by the affected communities, especially the legal profession, because it is the legal profession which utilizes the judiciary in the exercise of its functions. The discussion on the impact of political influence on judicial funding is particularly compelling, showcasing how external pressures can compromise the rule of law. As previous speakers have demonstrated, some politicians are not shy to actually pronounce their distaste of judicial assertiveness by our judiciaries. And this, to my mind, is one of the biggest challenges that we all face in our judiciaries, both as institutions and as individuals. It takes a lot of courage for us to stand up to the political whims of the ruling class, which of course, as what some speakers said, including us. The respect that we sometimes afford to each other is not reflected in how the political actors act out when the needs of the judiciary are put up for discussion. Furthermore, the book addresses practical solutions and reforms that could enhance judicial financial independence for judiciaries. These suggestions are grounded in real-world applications and encourage a collaborative approach between governments, civil society, and international organizations. I was surprised 3 weeks ago when the former Chief Justice of South Africa, in one of his farewell speeches, lamented the manner in which the executive in South Africa have constantly denied adequate financial support to the judiciary in South Africa, yet the glitter and the glimmer that you see in South Africa, you do not think that they also suffer from the same underfunding that most of our nations suffer. So overall, Judicial Financial Independence in Africa as a book is a significant contribution to the discourse on governance and the rule of law. This cannot be overemphasized. It is a well-researched, thoughtfully written, and serves as a vital resource for legal scholars, practitioners, policymakers interested in strengthening judicial systems across the continent. Finally, the book not only illustrates existing challenges, but also inspires hope for a more independent and effective judiciary in Africa. I thank you.
Thank you very much, Honorable Justice Hungwe, for those remarks. So very finally, I'd like to invite the final speaker, the Honorable retired Vice President of the Constitutional Court of Benin, Madame Marceline Beha Afuda, and I believe she'll speak in French, so please make use of those gadgets before you. Thank you. Welcome.
Thank you very much. Thank you all. I wish to, following all the presenters, I wish to congratulate this very great book by Mr. Conrad Bosire with all the co-authors. This book has been financed with the help of Konrad Adenauer Stiftung. I wish to congratulate them. The study that was done by the author allows us to have an overview of the challenges faced by the judiciaries in our continent. I've not yet read the entire book, and you can guess why it is written in English, but I was able to at least have an idea. I was able to read a good part of it thanks to the generosity of my colleague Matilda, who tried to translate a few pages for me. And I note that what we are talking about here is a situation which is common to all of our judiciary services, even if the systems are different. In Benin, I will share with you the situation of our constitutional court, which I know best. The constitutional court is an institution that was put in place after our national conference, because before that we had so many problems in the country, and we were forced to organize a national conference to sort some problems and especially protect human rights that had been violated a lot back then. So the Constitutional Court was created in order to protect fundamental rights, human rights, and public's freedom, to regulate functioning of institutions and public institutions, and to also control, or rather manage, presidential elections, legislature elections, and any referendums. To succeed in its mission, what financial means does the Constitutional Court have? First of all, when we talk about personnel, the members of this court are 7. They are judges and lawyers of great repute, or professors of law, and people or professionals of high reputation who have at least 15 years professional experience. You must have at least 15 years experience before you are a member of the Constitutional Court. So magistrate, professors of law, or teachers of law, or lawyers, each person has his salary, his financial means before he comes to the court. But the law stipulates that the members of the court receive a treatment, a salary for equivalent to that of civil servants. So he cannot earn less than other civil servants. They have certain rights, they have certain allowances, salaries which are not less than those of certain civil servants. Now, when it comes to the institutional itself, what are the budgetary allocations for the Constitutional Court? Its resources come from the national budget. The court does not have any other sources of funds, so all its finances are from the national budget. To prepare its budget, at the end of the year, the Minister of Finance sends what we call a framework letter to tell us, prepare your budget, but you don't need to go beyond this ceiling. And this is the same for all institutions in the country. It's not just for the Constitutional Court. There's always a framework letter that guides, that gives the ceiling when preparing your budget. Thereafter, the provisional budget is discussed with the personnel in the Ministry of Finance. Not just the low, but the high officials who look into the budget and verify that we followed the instructions from the ministry. Thereafter, the head of the institution, that is the chair, meets the Minister of Finance to discuss this provisional budget, and it's thereafter that this is sent to the Parliament. And at the National Assembly or the Parliament, we meet the Finance Committee to once again discuss and justify why we've included each activity in our provisional budget and why it is important to give us the necessary finances for all these activities. It is after these procedures that the budget is approved. Sometimes it is greatly reduced, and sometimes it is allowed, it is approved as presented. And this is the same for all institutions, be it the Supreme Court, or the National Assembly, or even the Ministry of Justice. It's the same procedure for all government institutions or state institutions. So you will understand that we don't have financial independence for our institutions in Benin. We talk about independent management. That is, once we have the budgetary allocation, we are free to manage it as we want, but of course, while following the different procedures and the framework instructions or letter. It's true that in other lower courts, for the Court of Appeal and the magistrate courts, for them there are different acts. For example, if a certificate, for the other courts, if the citizens are requesting for certain certificates, they can receive certain fees, they can receive certain funds, which are all, there's always some stamp duty for these government documents. But all that is sent to the Treasury. Just to tell you that our Constitutional Court does not have any means to generate any revenue. So we cannot talk about financial independence, but independent management. I wish to inform you that if we have other special needs apart from what we had indicated in the budget, we call upon financial partners like Konrad Adenauer, even UNDP that support us. And for very long, Konrad Adenauer Foundation has helped us to prepare our court reports, meaning that for us we cannot talk about financial independence, but independence in management. So for the last 20 years, I've never seen the president of the nation to denying us funds, but once we had a case because we refused to support his request to deny the citizens the right to demonstrate. So that time they refused to give us certain funds. But since it was the end of his mandate, that is how it ended. Thank you very much for your attention.
Thank you very much, Madam Vice President Emeritus, for those remarks and for some education on how the French system works. And yeah, so I think we very finally, we are almost at the tail end of this. Thank you for your patience. It's very rare that I get a chance to invite a Chief Justice to speak. I didn't know that you have to write a book in order to, to do that. But it is my pleasure now to invite the Chief Justice of the Republic of Kenya, Honorable Martha Koome, to make her remarks. Karibu CJ.
Thank you very much, Conland. Good afternoon, everybody. I'll be very brief because I'm standing in between two important things: the launch of a wonderful book and also lunch, which is also important. So mine is really to thank Konrad Adenauer Stephen for agreeing to fund this project and to walk this journey with very distinguished authors from 11 countries, to thank the esteemed authors and the editors for your very good publication. Conrad, you know you are my friend, but I think I'll be reaching out to Dr. Mwitsa Nkatha to become also my friend, because the journey she described of motherhood is, I think, the journey my predecessor, Chief Justice Emeritus David Maraga, was describing. Because Kenya, when we came up with our constitution, 2010, which is now 14 years ago, knew that the enemy of judicial independence is financial autonomy, and therefore made a provision for a judiciary fund to be established, whereby the judiciary will be drawing their budget and taking it straight to the National Assembly, and then when passed by the National Assembly, the funds will be loaded in the judiciary fund. Chief Justice Emeritus Professor Willie Mutunga struggled and came up with the Judiciary Fund Act, which was not an easy task also, because you find all manner of obstacles. And Chief Justice Maraga came up with the regulations on how to manage that fund. When I came in office in 2021, my commitment was to operationalize the Judiciary Fund. And I said this is one of my deliverables within 100 days. After all, the act is in place, the regulations are in place, so I'm just going to use my soft skills, invite people for lunch, we eat, and then I tell them operationalize the Judiciary Fund. Somehow it worked, because all what was remaining was a letter to instruct the central bank to open an account for the Judiciary Fund. And I found a file as big as this about the communication back and forth with the central bank and with the Treasury on just that one letter to operationalize the Judiciary Fund. After so much food, we agreed and it was operationalized. But I stand here to tell you, we have never seen money in that account. There is the act, there are the regulations, the account is open. The law says money will be loaded upon being approved by the National Assembly on that account. But we keep getting it every month or sometimes even late. So your book is most timely. And even to be launched at a very, very significant time when we are hosting this summit, which are centered on judicial independence. We couldn't have had it at a better time than now. What I can hand is that maybe the sequel to this book will be the testimonies of the Chief Justices on what they have gone through, the frustrations of having to deal with the Treasury mandarins, to deal with politicians in those committees of Parliament, so that they can approve the budget for the judiciary. Yet, as we have been told by distinguished panelists and all the speakers who have spoken, it has been agreed, including by the UN, that financial autonomy for the judiciaries is pertinent to judicial independence. And we need not make any new case to justify that judicial services are necessary. We need courts to defend the rule of law and to defend constitutionalism. And these courts exist in all the places, so they will require money. Justice Nyirenda, I don't have answers to your questions, but all I can say is that at least this book tells us there is hope. There are some countries that have given 2% of their GDP to the judiciary. We will live to know whether this 2% is actually dispensed to the judiciary for them to function. Because what we have in Kenya is we have a dream. Chief Justice Willie Mutunga put up the JTF, Justice Maranga put up the SJT, and now the social transformation through access to justice. We know the number of judges we need for us to function optimally. We know the number of judicial officers, magistrates, tribunals, and judicial staff that we require for the judiciary to function optimally. We know where we need courts of all class, from the primary courts to the tribunals to the high courts. We know, and we know what judges require. But when you now are given a ceiling, like my sister here from Benin, they are given a ceiling of 21 billion, which is 0.04 of the national budget. Where is the 99.6 of the budget going? That is the question everybody is in this room is asking. And I think this conversation needs to be taken to Kenyans and to all the people of Africa for them to know that the elephant in the room, which is impeding the independence of the judiciary, is the budgetary allocation. Let the IMF, the World Bank, all partners rally with these governments to make a budgetary allocation of at least 3% to all the judiciaries in Africa. Then it doesn't just end there with saying a proclamation or a declaration or a provision that we will give 3% of the GDP to the judiciary. It must be followed with details of how and when, and followed up with whether the money was actually dispensed as provided in the law. So for me, I'm very, very happy and privileged to be part of this wonderful forum, the summit of AJJF, and to be associated with this great book in participating in the launch. So I want to thank CAS, and especially Dr. Stephanie, who runs the Rule of Law program in Africa, for supporting the development of the publication. CAS has proven to be a very dependable partner in this region, especially ensuring that we pursue the values and the principles of the rule of law and access to justice. I also want to thank Dr. Conrad Bosile, the editor, and all the chapter authors for your excellent contributions. I look forward to the debates and discussions that will emerge from this publication, which I'm hoping will be now the testimonies of the Chief Justices who have had to go through this harrowing experience. This is not what I applied for the job. I can assure you, I think that is why no one lasts in this job for more than 5 years. It's a harrowing experience. So I thank all of you, and with your permission, we will proceed to declare the book formally launched, and I wish you wonderful, wonderful interaction with the book and a further conversation on where we are taking it, because it is not going to end here. It is going to end with the judiciaries getting their budgetary allocations and indeed functioning independently. Thank you. God bless you.
I shall help to push these chairs a little bit behind. Sure. I can help you up. There you go. Yeah. Yeah. So we're going to ask the Chief Justice to cut the ribbon to symbolize the launch. There we go. We used to do certain noise or clap. Yeah, we give the copies. Then we shall take 2 photos. The first one is the one. Then the next photo will include the authors. So please, the authors, be on standby. Please come up front so that you take the photo as well. Thank you very much. Thank you very much, everybody. The book is launched. So Dr. Justice has an announcement, but then the books are outside. Please pick them at your own time. You can go for lunch first or as you prefer. Thank you.
Thank you. Let us go for lunch and come back in 45 minutes, so that we can finish on time. So 45 minutes. Thank you.
Yes. Justice has done it. Okay, thank you. I tell you.
I'm sorry. I'm sorry. Thank you, my dear. Thank you so much. Have you? Where are they getting the copies?
Outside.
Have you announced?
Yes, I've announced. I don't know if they had.
Just announce it again.
So if you want to get a copy of the book, please get it from the door next to the corridor.
mention my name. Cypher Lee in the mix. Turn up the speakers. It's DJ Cypher Lee in the mix. Put some respect when you mention my name. DJ Cypher Lee in the mix.
Drown out the noise. Listen to the sound of my voice. And just take a second to refuel. 'Cause when you stop worrying about other people, life is kind of peaceful. So come, go through the motions with me. I want you to breathe in and hold it for free. Breathe in. And breathe out. Let go and release. This is your moment of peace.
Turn up the speakers. It's DJ Cypher Lee in the mix. Cypher Lee in the mix. Turn up the speakers. It's DJ Cypher Lee in the mix. Put some respect when you mention my name. DJ Cypher Lee in the mix.
Drown out the noise. Listen to the sound of my voice. And just take a second to refuel. 'Cause when you stop worrying about other people, life is kind of peaceful. So come, go through the motions with me. I want you to breathe in and hold it for free. Breathe in. And breathe out. Let go and release. This is your moment of peace.
Turn up the speakers. It's DJ Cypher Lee in the mix.
Judicial integrity and gender balance within the Zimbabwean judiciary. The other panelist is Keong Minyon. Please forgive me if I mispronounce your name. He's also an expert on cybersecurity. He is counsel for cybersecurity and the data infrastructure in the World Bank. He also represents the World Bank in the United Nations Commission on International Trade, which is concerned mainly with the standards of digital commerce. Sorry, I wasn't given the bios of the others. Ms. Oda, thank you very much. They are all going to share in the discussion that we are going to have this afternoon. So to start us off, let me call Misiko to come and make our presentation, after which we will proceed on. Thank you.
Thank you. Thank you very much for the introduction. So, yeah, do you have the slide? And sorry, do you have the remote? Or
we are coming down because of the slides so that we are able to follow.
Okay, so I ask, okay, no problem. So, UNESCO work in the area of freedom of expression and safety of journalists, and we started a program that is called Judges Initiative back a few years ago. And I'm pleased to introduce here our new program on artificial intelligence and the rule of law. So I will go through on, why AI matters in judiciary, our engagement with the members of the judiciary, and finally what we do under the AI and the rule of law program. Next slide, please. So, as it was mentioned in the introduction, so AI has immense potential for the justice system in helping judges to make a better decision, improving the processes, efficiencies, access to the cases, etc. But there are some other important issues that justice stakeholders need to consider as we prepare for the future in which AI is increasing use in the justice system. So in 2023, we launched a survey on the use of AI systems by the judicial operators. And actually, we find out that the majority of the judicial operators were familiar with the AI technologies, and half of them have already used AI tools such as ChatGPT for work-related activities, but only 9% receive training or have institutional guidelines or policy in place on the use of AI. And if we look at the use of AI chatbots such as ChatGPT, there is a number of variety of tasks that are performed by the judicial operators, such as searching, document drafting, brainstorming, explaining, analyzing data, verifying, etc. And we have some cases. These are the cases that we studied on how the AI is being used by the judiciary. And, you know, for example, in South Africa and Zimbabwe, law firm adopted AI tools for contract review and management of casework. We have other cases where, you know, AI has helped to do some work on translations, issue some summaries of the decision, etc. So AI has a potential for adoption in the judiciary in Africa, and sorry for the slide, which is not really readable, but there is a number of you know, cases and opportunities, such as the use of language tool, you know, open legal repositories, summaries, case data, court proceeding, etc. For which the AI can be used and can accelerate the processes of the judiciary. Next slide. But when it comes to the risk, because all these technologies come with the risk, there is a number of risks that were identified also by the survey members of the judiciary, such as the quality of the output, the data protections, copyright issues, you know, the lack of transparency, because AI is like a black box, and the biases, etc. And the majority of the responded call for the guideline on the use of AI. So let me now come back to UNESCO. So we are an intergovernmental UN organization created after the Second World War with a beautiful mandate to promote the free flow of ideas by word and images. And we do it today by protecting freedom of expression, promoting the freedom of press, and the safety of journalists. And we started to engage with the judiciary system because they are essential to protect the freedom of expression through enactment and enforcement of laws and policies. So, and we do this by, you know, reinforcing the capacity and knowledge of judges, prosecutors, lawyers, and other actors in the judicial system on international and regional standard on freedom of expression and safety of journalists. And so we have a number of on-the-ground training of the trainers, massive open online courses, as well as toolkits and the guideline, which, you know, we have in 2021 published the Global Toolkit for Judicial Actors on freedom of expression and safety of journalists. Next slide. We have a book on the legal standard of freedom of expression in Africa, which is a toolkit for judiciary in Africa. Next slide. We have this guideline for the prosecutors on cases of crime against journalists. And we also have signed a number of memorandum of understanding with the Regional Human Rights Court in Africa to formalize cooperation and facilitate the development of joint activities in the regions. So over the past 10 years, we have trained more than 34,000 judicial actors in almost all our member states under the UNESCO's Global Judges Initiative. So when it's come to the AI, which is the topic of today's panel, and I think we will have a very stimulating discussion with the rest of the panelists. UNESCO has issued in 2021 a recommendation on the ethics of AI, which was adopted by our member state, and to follow up to the implementation on the ethics of AI, we launched this AI and the rule of law initiative with the aim of engaging stakeholders in the justice system, like you, on the discussions on the application of AI and its impact to the rule of law. So we have, again, published this year this global toolkit on AI and rule of law for the judiciary. So just to give you a bit of, content on this global toolkit. So, for example, we highlight some of the applicable legislation relating to AI, not only at the international level, but also regional level and national levels. So, we have the International Human Rights Framework as an overarching principle, but then we get into also the specificity of the regional laws that apply in relation to the AI. Next slide. One of the also the important elements, and again, this is just an introduction, not a training, is that there is a different level of human involvement regarding the use of AI, and it is obvious that because AI systems are like a black box and there are biases, the toolkit helps judiciary to addressing some of the question concerning the extent to which human should be involved in the AI, and the severity and probability of the harm is higher, then it requires much more human intervention. So and some of the right that the chair of the session has already mentioned that can be impacted by the AI, include the right to non-discrimination, the right to privacy, the freedom of opinion and expression, also the right to life and personal security. So we have a MOOC which is available and free to access on AI and rule of law for the judiciary. And next slide. And now we are also working on the guideline, a specific guideline for the use of AI system in court and tribunal, for which we are proposing a set of principles and specific guidance for the judiciary to prevent adopting AI tools that do not comply with human rights standards, and in order to prevent the misuse of AI system and enhance the benefit of those tools. So the guidelines are divided into 3 sections. We have a list of 13 principles that are important to respect when adopting the AI system, and plus specific guidance for the organization that are part of the judiciary and the guidance for the individual members of the judiciary. So as part of the principles, of course, we have human rights, the notion of proportionality, safety, transparency, accuracy, human oversight, etc. And yes, last slide. And currently we are calling for contributions to inform the development of the guideline for the use of AI system in court and tribunal. So you can scan this code and also share your comment and feedback. And we are also pleased to announce that in November, from 19 to 21 November, we are hosting here in Nairobi a regional training for the member of the judiciary. So from the judiciary training institution, but also judges on the AI and the rule of law. So if you are interested, please feel free to be in touch with me. And Yes, I stop here as an introductory presentation. Thank you very much.
Oh, okay. Thank you very much, Msiko. So that we have like an interactive session, I'll pose two questions to the other presenters so that you cover, I mean, it's a bit of what you already have. Then we'll come and bring in any other questions. The first two questions are for Justice Maria Dupe. As the Zimbabwean judiciary introduced AI or any form of technology for case management, if so, can you share the features of the system that you have in place? That's the first question. The second question, because of time, how does the integrated electronic case management system that promotes and supports the judiciary fared in technology? Please, if you can answer those questions. Take about 6 minutes.
A very good afternoon to you all. Thank you for allowing me this opportunity to share the Zimbabwean judiciary's experiences with the integrated case management system. Zimbabwe digitized in the year 2022 in May. It did come up with the IECMS system, which is the abbreviation for the Integrated Case Management System. This system is a digital platform designed to manage cases. It is web and computer based. It is a system that we use to track court processes. This system has a number of features. It has two main features. The first one is electronic case tracking. The second one is remote hearings. We do hold virtual hearings. This entails hearings where litigants are able to participate in hearings from across the country. Hearings can even be conducted from one's home, one's office. The features of the electronic case tracking system are a litigant is now able to file pleadings online. We no longer accept papers. You cannot do your pleading, do your summons, do your plea, and be able to file the papers, the documents at court, because everything has to be done online. Ideally, our system is supposed to be allocating cases electronically, but we haven't gone there yet. Our technocrats are in the process of coming up with that component of the IECMS system. This system also sends updates to litigants. When you have filed your plea, you are required to file any other document after that. In terms of the rules, the system will alert you of the fact that time is up, you are now required to file the next document. The system also sends notifications to judges. If a case is ready for set down, the system will let you know that this case is ready, pleadings have closed, you are now supposed to set down the matter for trial. At the end of the month, perhaps, or periodically, the system will send you reports as required. We do have statistical reports that the system generates at the end of the month, and these reports have been most useful because we use the reports for monitoring and evaluating the performance of the judges. We have also started using the data from the IECMS system for performance management. We have introduced a performance management system that monitors the performance of judges, and this information from the IECMS comes in handy in this process. Looking at the features of the case tracking, electronic case tracking system that we have in place, it is very clear that there are components of AI. Why do I say this? Because the system automates tasks. It does analyze documents. Remember, I talked about the reports that the system is able to generate at the end of the month, the statistical reports. And how does it do this? The system uses the data that is in the system. I understand in some other jurisdictions, there is software that allows the system to write judgment for the judges. We don't have such software in our system. To ensure the success of the system, how did we go about it? We introduced the system in phases. We had the Constitutional Court, the Supreme Court coming on board first so that we would be able to manage the process which was new. The Labour Court and the rest of the High Court came in later on in 2023, and we still have the Magistrates Court to still come on board. We are hoping that the Magistrates Court will be able to tap from the experience of the superior courts that embarked on the IECMS first. Some components of the work that is done by the magistrates, however, is done online. You find that in bail applications, we have been conducting bail hearings virtually so that we cut down on the transport costs of having to ferry the accused persons to court. When we introduced this system, we realized that it was very important that all the stakeholders be trained on the system. Remember, this is an integrated case management system. We have the lawyers, we have the NPA, the prosecuting authority, we have the litigants themselves, the judges and the registrars of court, all the support staff. They needed to be trained, and we carried out extensive training to ensure that everyone was up to the task. We also had a change management program that we put in place to ensure that the system is accepted. We also have legislative instruments that we put in place in the sense of rules to enable the process to be properly regulated. That is my answer to the first part of your question. I'll now deal with the second question that deals with how the IECMS, that is the system that we have in place, helps strengthen the rule of law. I should shorten very well. I want to talk about access to justice. What I have noted is that the IECMS has greatly improved access to justice in my country. Why do I say so? Because a litigant can easily conduct hearings from their own home. The litigant can access information on their own computer for as long as they've got internet facilities from their own home. They have information about what is happening with their case, and they look for it on their own. In the past, when we were in the physical world, when pleadings were filed on paper, litigants had to come to court to find out what is happening about their cases. That is no longer the case. Now you can find out what is happening about your case on your own because you simply go to your phone, as long as you've got a smart gadget and you've got internet facilities. There's no need for you to travel to the courts anymore. I'm sure you are asking yourself how the indigent litigant, the poor litigant from the rural folk, is able to navigate the system if they don't have a computer. What we've done is we've set up hubs, internet hubs, information kiosks at the various magistrates' courts across the country. And our litigants, our lawyers, and anybody who might want to access the system or take part in virtual hearings is able to go to the magistrate's court where they will be assisted by fully trained e-filing officers to navigate the system, to file documents, and to follow proceedings and file documents. What we've realized is that because of the transparency of the system, we now don't have any allegations, queries, perceptions of corruption because everybody knows, has information, can access information about their case from the system on their own. Judiciary independence is also crucial for rule of law. Why do I say so? Once the system is transparent and all information is laid back, the litigant is able to follow all proceedings, can check out their own rulings. Their own rulings are placed on the system. If you want to know what the outcome of your matter is, you just simply go to your computer and you are able to see your own ruling. And once the system starts allocating matters, there will be more transparency and complaints of corruption will be reduced. Apparently, I haven't finished because of the time constraints. Thank you. That's what I have to say for the time being.
Thank you very much, Judge. June, you've been with the World Bank for quite a while, and you have even been involved in some African judicial systems compared with the Korean one. Please give us your experience and how you think the judiciaries can harness technology in the discharge of their duties. Please.
Thank you. Good afternoon, everyone. It's a great honor, and it's also quite scary to be talking about access to justice as well as judicial modernization in front of probably the greatest subject matter experts around the world. So as we have just heard from the Madame Judge President, that technology can unravel many of the traditional barriers to access to justice. And for instance, case management systems, which are already operational in African countries, including Zimbabwe and Kenya, have resolved many of the issues that are associated with the physical handling of documents. To this end, I would like to bring your attention a World Bank publication on South Korea's digitalization of its justice system. So this report, I must warn you, is not a display of self-congratulation or an attempt to say that judicial digitalization in South Korea was easy breezy or straightforward. Rather, it is a complex story that shows a multi-year journey marked by trial and error and lots of error. So the best part about the report is that it's very open about the missteps that it took. Early digital initiatives in South Korea had to be suspended due to low adoption rate, as well as many electronic case management systems that were developed in a fragmented manner had to be rebuilt from scratch for interoperability. So as we have said, it openly narrates Korea's comprehensive approach that required a lot of reevaluation and correction, and covers different areas from judicial culture to the governance system, power dynamic between different judicial entities, law enforcement, the prosecution offices, funding, and et cetera. So for countries considering a similar path, the report does not claim that South Korea's approach is a global best practice, nor does it say it's a prescription for a pan-Korea. Rather, what it does is that it acknowledges that setbacks are part of the process and that overcoming them requires careful planning, engagement with stakeholders, as well as a willingness to change with the challenges. So for lessons from South Korea, especially for African countries who have yet to fully adopt the digital judicial tools, there are many, but I'll focus on the primary lessons on the report. In Korea, the primary obstacles to broad adoption were not necessarily technological or related to the legal framework. Rather, it was human-centric, related to the judicial culture. The key to overcoming this hurdle required building trust by addressing judicial culture and ensuring that the judges were involved in the decision-making process from the outset. The report emphasizes that despite Korea's status as an IT powerhouse, and due to its judiciary having the financial independence to make decisions without reliance on other parts of the government, the digital transformation still took 20 years to gain real momentum. It was only after there was a cultural shift. And once these human-centric issues were addressed, the broader acceptance of technology followed. One of the key takeaways from the report is that judge-led initiatives, both from top-down leadership as well as grassroots, bottom-up movements, were critical in creating and establishing a culture accepting technology. And I also want to bring your attention to the importance of trust. As we all know, trust is a perception that is often required when a process or an outcome is unclear or not transparent. In Korea's case, judges needed to feel confident that the technology would enhance their delivery of justice rather than detract from it. This required a period of trust building where judges could see firsthand how these technologies were enhancing their efficiency while maintaining procedural integrity. Judges were initially resistant to digitalization due to concerns about undermining the authority of the courtroom, the reliability of technology, and the perseverance of judicial fairness. Judges were skeptical that technology could adequately replicate the personal face-to-face dynamics in a real courtroom setting. And building trust through high-quality technology, secure platforms, and training programs at a pace that the judges were comfortable with was essential to overcoming doubts. And the report underscores that digital transformation in the judiciary is not a quick fix, but rather it's a long-term strategic endeavor. And by sharing both the challenges and the successes of the Korean experience, we try to provide valuable insights for any country embarking on a similar journey, and reminding us that while the process is difficult, the potential benefits to the justice system and society as a whole are immense. I'll stop there for now. Thank you.
Thank you very much, Dr. Melissa. And Dr. Mutasa, my apologies. the initial assignment, the letter of assignment that I was given initially didn't contain your names, and I'm very, very sorry about that. And that's why it's like you're taking me by surprise. All the same, you have seen from the program, Dr. Melissa Omino is currently the director of the Center for Intellectual Property, and has a wealth of experience in the use of technology in various aspects of our work. The same with our brother, Chris, who has qualifications in artificial intelligence, and has served in quite a number of organizations. The details of their bios are on the program. I want to give them each 5 minutes to give us, to give us their experiences and show us how we can use IT in the discharge of our duties in the judiciary. Sorry about that. Thank you.
I hope this mic is on. Good afternoon, everyone. It is such an honor to be in this room in the presence of so many honorable judges and chief justices. The last time I was in a courtroom was 11 years ago, so I'm so nervous to be speaking here in front of you. But I'm also confident because this is an area that I deal with every day. The Center for Intellectual Property and Information Technology Law is a research center based in Strathmore University. And our key thematic areas are artificial intelligence, intellectual property, data governance, and something very murky that we call ICT law and policy, which is wide. So when we talk about artificial intelligence, it's first viewed as a foreign concept, something that is developed elsewhere for use here. And the first thing that we did as CIPIT in investigating artificial intelligence in terms of getting towards looking at the law and policy around artificial intelligence was to investigate whether there is AI being developed on the continent. And we conducted a mapping exercise to collect, or rather to, in research we say, to document the applications that have actually been developed by Africans, for Africans, and to solve African problems. And we have that mapping on our website, and we are constantly updating that database. So artificial intelligence is not a foreign concept. It's something that is also being developed here in Africa by Africans. So in terms of that mapping, we decided, great, this is happening here. How do we talk about artificial intelligence in a way that represents the Africans who are working on it? And that sort of led us into the conversation that is currently happening in several countries, which is the AI strategy process. All the countries in Africa are considering coming up with AI strategies. There are about 10 countries that have published AI strategies or are documented as having conversations on AI strategies, and Kenya is definitely one of them. And to be more specific, or to ground it in the room, there are questions about using artificial intelligence in the judicial system. There have already been mentioned some of the negative impacts of artificial intelligence, such as the biases that the algorithms that run this technology might have. When we think about it from a CIPIT perspective, we say, well, if it's Africans who are creating these algorithms, what would those biases look like? We know that a lot of the biases have been mentioned to be racial biases, right? So we said, okay, if Africans are coming up with it, will Africans be racist towards other Africans? I think there's case law that you can, you know better than I do about xenophobia, for example, happening. So that's the type of bias that we would look for that is Afrocentric, not European-based. The other question we asked ourselves is something that has been mentioned in the first presentation about how it could enable access to justice. So it can enable access to justice, especially if you're thinking about language. A lot or a majority of people in Africa do not speak English. They speak their native tongue. And when you have artificial intelligence, the bias is to have it conduct its services in English. But there are AI researchers on the ground who are developing artificial intelligence tools in local languages. And I can mention in Kenya we have the Ken Corpus, which is based at Maseno University, who are actually conducting right now the collection of African language data. There's Masahane, which is an African collective, but is headquartered in South Africa, that have collected a large number of languages. And this gets to the interesting part for me, because how did they collect the language? They collected the language first by conducting what is called text data mining. Text data mining is essentially putting loose an algorithm on the internet to troll the internet and copy and paste anything that it can find that you tell it to. That's what that Masahane did. And you can imagine, for those of you who work in the commercial division, already we're thinking about copyright and intellectual property. And there were issues around copyright law, because a lot of the language that they found was on a website, a religious website, the Jehovah's Witness website, which translated the Bible into African languages. And the copyright for those translations belongs to that organization, which is an American organization. There should be thoughts that are arising in you about how an American organization has copyright over African languages. So then that led us into another area of research. We asked ourselves, what happens when you collect language data? Who owns that language? And it led us down the rabbit hole of thinking about human rights and language as culture. And we know that culture is a human right that is recognized. But I'm very happy to be speaking in this room because I'm speaking to lawyers. Usually I speak to techies, and techies think I'm crazy when I say that language is part of culture and culture is a human right, and just because you can collect it on the internet doesn't mean it belongs to you. Techies do not understand that. This is the frontier or the future of the cases that will be arriving in court soon. But it's not just techies who are the issue. Techies may not understand. So part of what we do at CIPIT is to teach techies to understand, first of all, intellectual property, which unfortunately is a very Eurocentric concept. So after talking to them about what copyright is, giving them the definitions that are all the way from the European conventions of 18th and 19th century, we then have to break it down and say, yes, that's copyright. And probably Jehovah's Witness does have copyright based on the Eurocentric view of intellectual property. But if we now come and think about human rights and use an African lens to apply human rights, then you have to ask yourself about the ownership of this language. And we have a wonderful way of explaining that through other indigenous communities, such as the Maori. I'm so sorry. Such as the Maori, who have gone through many lengths to protect their language. Not only their language, but their culture and the indigenous knowledge that their language and culture carries. So the interesting thing is, it's not just going to be a clear-cut copyright case or intellectual property case if such a case comes before a court. It's going to have to be a little bit more nuanced to fit the African context. And because of this, there's been conversations about licensing, how we can...
Yes. Are you able to hear?
Can you hear me?
Are you hearing? Yeah?
Earlier was...
Sorry about that. Sorry.
I think you can hear me now.
Yes, okay.
You can see that the forces that be are working against me, but I will resist. If this is what we are anticipating at CIPIT, to land within several courts across Africa, because languages exist across Africa. But it's interesting to see that there's a conversation around licensing. So the researchers, because these African researchers, as has been mentioned before, there's an issue about lack of funding. The researchers are funded. The funding instruments or the grant agreements that fund these researchers
Sorry, I'm told that it's a construction going on in the next plot, but somebody has been sent there to ask them to hold on for a while. You need peace with your neighbors.
I think you can hear me. It's not that bad. Okay. So that's part of the technological issues concerning artificial intelligence that might land within the judicial system, and where a human rights or African lens needs to be applied. But more than that, or rather in the present moment, my concern is as the AI strategies are being developed, I wonder if the voice of the judiciary is really within those rooms where these strategies are being developed. I know, for example, that there might be working groups that are put together, and the majority of the time those working groups represent the tech industry. The tech industry, big tech, people who are more closely related with technology will be in that room. But I think the judiciary also needs to be in that room because of the uses that have been mentioned here, but also because of how the strategy will definitely influence how you might be able to decide cases of artificial intelligence. So I think I'll stop there.
Thank you very much. Chris?
I hope that sound will not come again. I want to write on the protocol that has already been established and start by reflecting on a conversation that I had with my grandmother. I don't know if anyone here has a fond relationship with a grandmother or has had. You become a favorite child. I was the one who was the source of knowledge for everything. She would phone me and ask me for clarity over everything. Then suddenly, around June, May, there was a phone call to say, I now have someone who's smarter than you on my phone. WhatsApp had AI, and she could ask AI on WhatsApp anything and would be told what she thought were the correct answers. But there was trouble in paradise after 2 weeks. I got a phone call that AI is lying. This thing is biased, and all the issues that we were talking about were reality. But reflecting on that, you realize that the future is here. This is my grandmother in rural areas, and she was already interacting with the AI overnight. But one of the challenges that we face here as people in the legal fraternity is that AI and technology is moving faster than regulation. And the boat, I mean, it has already bolted. And we don't have the mechanisms now. We are now trying to put guardrails, but already AI is here. And some of the issues that we are seeing, I'm trying to shift away from things that have already been said. Because AI was defined as computer systems that, or processes that, or technology that would replace human intelligence or mimic human intelligence in visualization, in processing, in predicting, in analyzing, in different applications of AI. And of interest these days is generative AI, like my grandmother was using. But I want to pose these questions, and I know they're going to come into your courtrooms soon, and perhaps maybe you need to start preparing about it. The legal person would issues of AI. If it's going to think like human, if it's going to generate like human, what you have taught us in law school is that a business is a legal, juristic person. But so what is AI in this case? Because AI can inflict damage. If you have a self-driving car, AI-operated self-driving car, and it has an accident, people die. Who's responsible? And what law are you going to apply in that case? So we've got several issues. Maybe I'm being dramatic about the self-driving car, but even closer to home, my grandmother will tell you that she's being given health tips. She's interacting with AI over different subjects, different fields that AI is telling her. So in terms of liability and damage to emanate from the person, legal person, would, if we are able to answer the question, maybe perhaps we'll be able to answer who's liable for damage. And then the accuracy has already been spoken about. I like that from the presentation from UNESCO that we have had that several law firms are already using AI in Zimbabwe and South Africa for routine tasks like creating contracts and etc. AI has a place even in the courtroom, but I hope it will not replace the people here. I was easily replaced, but because you need the human element in judgment, right? You need the human element, the empathy. I don't know if AI has got to that stage of being able, or someone might argue to say that, okay, maybe that's a bonus. But I'll tell you that the data that AI interacts with was created by human beings. And some of them did not even have the empathy. So the biases will be inherent within the data sets already existing. Not to mention the algorithms that are developed. Tests have already shown that these biases are evident in the existing AI systems. And then the data privacy and security concerns. This is a big one. Imagine the data collection that you have. Now, with AI and its processing power, it collects even more data. It's collecting more data, but it has not asked for permission from your courtrooms to collect that data. If it's a surveillance tool, it doesn't have a warrant from your courtroom, but it's doing surveillance. If you just type P in your Google search bar, it will autocomplete with something that you are used to. Please don't show your neighbor if you're typing P. For me, it will type pasta or Premier League or anything like that. I don't know what it will autocomplete to you, but it's based on behavior. So someone is collecting that information. I mean, AI is collecting that information, not someone. When we are able to define it, perhaps we will know what it is. But it's collecting that information and creating a profile, your profile, that you don't know. Now, I like that the previous speaker spoke before me. It's a good initiative that we have our own Afrocentric AI systems. Most of our internet that we use here, if I ask you all the applications that you have used ever since internet started, it's possible that less than 2% of the applications that you have used are from Africa. You use WhatsApp, you use Facebook, you use YouTube, you use all these other apps. They are in a different jurisdiction with their own laws. If you are going to Google how to make a bomb, it's not going to send an alarm system to the security systems in your country, but it will send an alarm system to the US, and you won't be able to get a visa because you have been Googling how to make a bomb and etc. I hope you understand where I'm getting at. So we've got an issue here with the AI systems that we are importing and that are also governed by the laws that are outside our jurisdiction. So I would applaud that, yes, we are having our systems being developed here. Then we've got issues to do with intellectual property and AI. This one has been different. I think we have been solving it in silos. Universities have got issues with that, schools have issues with that, and they've been solving those issues on their own. We have not yet, maybe in Africa, had issues, but I can tell you in Europe, many journalists are taking ChatGPT to court and authors to say that, no, someone has stolen, this system is stealing our property. And of course, the questions of who is AI and at what point is it generating new ideas, really, is still coming to play. So some are insisting on placing a watermark. If you're going to have an AI-generated image, you have to those are other laws that in other jurisdictions. But here, we have not yet crossed that bridge. So we are vulnerable if we don't create these guardrails. But I can tell you the systems are advancing, and they are advancing very well. What role can we play as the process of lawmaking through parliament and so forth is delaying? We can still make decisions that do affect when they come to, I guess, our different jurisdictions. I can give you an example. I believe in 2014, in Spain, there was a case, Google was taken to court about the right to be forgotten. And it became a precedent over years. I think only 4 years later, it's now part of the law in Europe that everyone has a right to be forgotten. But that law, the right to be forgotten is only enjoyed in Europe. If you do search a Google search in Europe, certain results will be omitted because the people there have the right to be forgotten. But if you do the same search in Africa, the results will appear. Because Google is also fighting back. It's saying we don't create this data, we just... so imagine you make a ruling and you say, ISP so-and-so has to take down this from the website. Google will not listen to that directive. And I guess there are other issues that are related apart from the right to be forgotten. Who here is able to order in an instant Twitter, okay, it's now X, and all these other companies to come and help with evidence? You want to collaborate evidence in court, because these are the systems that are being used in our countries. So unless, and until the time when we talk about digital sovereignty and the different initiatives, we are going to have a problem, because now you can't solve a case because you're waiting for the courts in the US to determine whether it's also a law or maybe it's free speech in their territory, and they can't entertain your petition, and etc. And then the list goes on and on. So we do have a role to play, but I can assure you, someone is going to come knocking, because AI is here. It's on everyone's phone. It's on WhatsApp. It's everywhere, and it's popping up. And the technologies are coming without regulation, and at a faster pace than we can, regulate. Thank you.
Thank you very much. Thank you very much, the panelists. There's a time a friend of mine said, we live in an era of, what did he call it? Technology, the tyranny of technology. These advances are here. You can't do without them. You need to know how to use them. You need to know how to apply them. Especially those of us who are in advanced age. This creates a lot of challenges for us. I was speaking with a colleague judge sometimes back, and I asked him his email address. He said it is confidential. I realized he didn't even have one. So, I mean, technology is advancing, and you have had the experts tell us the challenges that are there, and the prospects and the potential that is there in technology. I want to open up the discussion to the plenary and entertain questions and comments, especially those who have already utilized these applications. We will benefit from your input. I can only see ladies. Thank you. That's great. Oh, 4 ladies.
Tanzania.
Madam, thanks. As you make your minutes. Please make it short. Somebody said make it short and sweet. Thank you.
I would like to share the progress that has been done by the judiciary of Tanzania in adoption of AI. So the judiciary of Tanzania has incorporated AI tool. It's called AlmaWave for transcription and translation. So this helps in breaking down the language barrier. In Tanzania, we speak Swahili a lot. So the proceedings most of the time in courts are in Swahili, but for the judges, you have to record them in English and deliver the judgment in English. So now the work of the judges has been reduced a lot because now we listen and make the judgment. So far it has been installed in 11 courts, and so far it can transcribe from Swahili to English, and it can do the translation from both Swahili and English. So that's what I wanted to share.
Thank you very much. Just Murgo.
CJ Emeritus, I would like to just make a comment, but it's about a joke you once told us, which is besides the Kenyan judiciary being very much technologized since your tenure. And I just want to focus on the joke. I don't know if you remember, you told us a joke once where there was a weighing machine outside a shop somewhere you had traveled. And you had a friend with you. And when you got on the weighing machine, it gave you the weight. But when your friend, who was slightly larger in size, got onto the weighing machine, the weighing machine told him, one at a time, please. So I'm not so sure where AI came into the picture there, but I thought I would just remind you about that joke. Thank you.
Okay. Thank you. The panel, very enlightening. Monica Mbaru, Kenya. My lords, my ladies, I need to make this comment with a tremendous respect. Even before AI, we had technologies specifically developed to assist persons with disabilities. Children who are not able to access services in schools, people who are not able to do certain things because of the barriers that are in society, that remote control, that vehicle that is without gears. They were all initially meant for persons with disabilities and the elderly. So the human person is still necessary to regulate whatever else that has been now brought into the space for accessibility and reasonable accommodation for persons with disabilities, but again, embracing technology and AI to assist us in our work, but also remembering that there are people's lives who are dependent on these facilities to ensure that they are able to cope with life because of different barriers in society. Thank you.
Thank you very much. Yes, madam.
Thank you very much, Chief Justice Emeritus, for the wonderful panel, and thank you to the presenters and also the discussants for the enriching discussion. As you were speaking, oh, sorry, my name is Julie Madheka, I work with the ICJ Kenya. As you were speaking, I kept on reflecting about the fact we often involve ourselves in the work when we see a gap, and then we innovate. And how will that then work in the judiciary? Because we find that the law is very rigid in itself. Used by our judges, therefore limiting the creativity to innovate and create. how then will we integrate AI without taking away the judicial independence for a judge to sit and say, there is no law around this. I therefore push it back to Parliament, I push it back to the people for you to think about this because there is a gap and I can't see it. Thank you.
Yeah, I think I'm the last person on the queue.
Yes.
Thank you, sir. I have two issues. The first one is the context within which we are discussing AI. Is it within the context of the fourth industrial revolution, or has AI come on top of the fourth industrial revolution? Because I think before COVID, we were being told that we are going to be replaced by robots. So immediately after COVID, then AI pitched up. So we are a bit confused because even as we were discussing the fourth industrial revolution, we could tell that while some of us are on the fourth industrial revolution space, there are those who are in the first. And in this continent, 80% of the population lives in the rural areas. They speak local languages, they eat local food, they do their thing traditionally. So whether you have robots in town or not, all they know is that they have a phone which can do things that things have changed. So I do not know how we are going to manage this movement. During globalization, Africa was very clear that globalization was uneven and it was going to put us in a worse place than we were before it. And we were convinced by some of our friends, no, don't worry, you can get on the net. Today, we now know what globalization did to Africa. So should we rush at the same speed? Should we not take time to understand what AI is and how we fit in and how we can migrate from one stage to another progressively? My last one is a question. We are talking about knowledge. Knowledge is extremely expensive to create. Indigenous people have got knowledge that has evolved over centuries. And then all of a sudden, it is in the internet. Nobody has taken time to pay back the cost of not just creating the knowledge, but also the custodians of this knowledge, paying them back. Women have been custodians of knowledge for centuries. Today, my children don't even ask me how to make my local dish. They go on the Google, and they can make anything from Google. So what happens to that knowledge base that women have been custodians of for millions of centuries, and now it is now on Google? Nobody can be able to claim their rights in terms of ownership. So these are some of the questions that really I think we can discuss here. I thank you.
Thank you very much. Thank you very much. I think we don't have much time. I want to give the panelists at least 1 minute each so that you can respond to some of the issues that have been raised. Yoon, you want to?
Yeah, I grabbed the mic first. So,
thank you.
I want to try to address most of the questions that were told. So in South Korea, for the past 4 years, they've been working on implementing AI into their judiciary. And some of the applications that are being introduced right now include predictive analytics for case outcomes, qualitative analysis of claims and evidence, online dispute resolution with automated decision-making, and support tools for individuals representing themselves in court. Okay, so they've been working for quite a bit. Next, regarding the Industrial Revolution, I just want to distinguish the discipline of AI. So a lot of people talking about AI nowadays are talking about LLMs, right? The large language models. And there was a time when big data was considered AI. So while it's quite too early to tell, compared to other economic evolutions such as the Industrial Revolution or the internet boom back in the 90s, which really amplify the ability of the high-performing individuals, the effective LLM is somewhat different, where it's not really benefiting people at the top of their game, right? Like, I don't know how many of us have used ChatGPT, but you tell it to write something, it's not good enough for us, at least the lawyers, right? But then what it is good for is for people with intermediate skills, such as nurses or such as paralegals, to really augment their skills to come up to a level that they wouldn't be able to otherwise. And these LLMs, it's going to be a driver of economic development. However, what's a critical issue, as our colleague here, Dr. mentioned, is that the cost of training LLM models outside of English becomes exponentially expensive. And this is something that we need to watch out for, because it's going to create a visual gap. And I know that Microsoft out of South Africa is working on training these models, but they're still having a lot of issues because literature is just not available to them, or at least not readily available. So I'll stop there and give others a chance to talk. Sorry if I talk too fast.
Dr. Mino? Yes.
Thank you so much. I can jump right in where you left off when you're talking about Microsoft collecting indigenous languages, right? And what happened, the first example I gave you is what people were doing about 4 or 5 years ago, which was going onto the internet and looking for local languages online. Now, because they face the problem of copyright, they decided that they would go into the communities and record the communities. So they are in the communities recording them, asking them to talk about their culture, how do you count numbers, what do you call this, give us a sentence. And people are really wanting to share, and they're sharing. But in the sharing, it's touching to the last question's point. They're also sharing indigenous knowledge that is owned, right? But when they're collecting this knowledge, in terms of intellectual property, when you make a sound recording, who owns the sound recording? The person who is making the sound recording owns it. So then the question comes to what happens to that part of culture and indigenous knowledge? And that's where we are having the conversation starting. And it will definitely end up in the courts should the indigenous communities get the money to go to court. So it might not, well, something like research centers like CIPIT are really interested in this, and we are creating that voice. So we are very much valid. In terms of recipes, it's a whole different thing. We're still going to go back and rely on intellectual property and Eurocentric views of copyright. But these languages that certain big tech who are funded are going in and collecting one-on-one is the area that we are now looking at and asking questions as to what is the benefit that is going back to that community. Because Microsoft cannot just go and collect language data for no reason. It is a profit-making company. So there is something that they've seen that they're going to make a profit on. What happens to the community that has literally lent its voice to Microsoft? Are they being paid $40 for 5 hours of sound recordings? Is that equitable? Is that fair? The people in this room are going to make that judgment. In terms of 4IR, I think he answered it. Artificial intelligence is actually not new. If you talk to the techies, they'll tell you this is not a new concept. It's been there for 50 years. It's just reiterating itself in different ways. So the issues are in these nuances that are coming up.
Thank you. Chris, 1 minute, please.
Okay, I'll try. So apart from the language bit, it's also the context, the localization of AI. I'll give you a quick example. In English, there are first cousins, second cousins, third cousins. In Africa, we are one family. My father's brother's kids are my siblings, so to speak, in our culture. And so I'm just using an example to say, apart from language, there's this localization. So there's a lot to learn from these systems. And I agree that the data collection, and some of it is automated without our knowledge. When we say accept, I'll give you an example. Because we spend a lot of time together in the same room, when we go home, Facebook is going to suggest that we are friends. Why? Because it has accessed your location services on your phone and my phone and says these people are in the same room, they probably know each other. And all that is part of the terms and conditions that we click accept to. So data is also being collected in other ways, even from metadata. There are people that you frequently call and all that, of course without a warrant from your offices, but with consent as we click accept next, and
and etc. Thank you.
Thank you very much. Just Dube, then we...
Okay. I'm really worried about information and knowledge.
Yes.
There's a lot of... I was saying that I'm really worried about information and knowledge. There's a lot of information that AI is using without the consent of the holders of that information, or even copyright holders of that information. Yes, we must embrace AI, we must embrace technology. Yes, we must embrace technology and AI, but as legal persons, we have to remember that AI is infringing upon the rights of many people. What the different jurisdictions need to do is to come up with legal frameworks that protect the holders of this information, or even the copyright holders. And also the danger that the information that you may get from AI is not reliable. They don't always give the correct information. So there's a need for legislation to protect the information holders of this information and that.
Thank you all.
Yeah, thank you very much. So one comment, I mean, from what I listened to the panelists, I really realized, you know, before the area of AI, I mean, what is really important is, you know, digitalization. You know, we have this example from Korea. And when those questions about the copyright, I mean, it's amplified by AI, but we had already those issues, you know, before the AI, when we move on the digital world, the issues of copyright and what you raise about the importance to preserve traditional knowledge, indigenous knowledge, and while at the same time making it accessible. And it's always a matter of, I mean, balance, which, you know, the copyright law try to respond. But for example, within UNESCO, we also have a very interesting way, because we do both. We protect, you know, intangible, tangible cultural heritage, but at the same time we promote the knowledge sharing. We promote the free flow of information and knowledge. And one of the way we do that, I mean, you know, I'm sure you are familiar with, you know, UNESCO's World Heritage Site list. So once we list the heritage as, you know, as of global significance to the humanity, it's raised a level of visibility which become, you know, a common heritage of humanity. So it's become accessible to anyone, you know, it's attract mass tourism and so on. But then we need a balanced policy from the government to be able to preserve those sites, because once you attract all these tourists, the site can be also damaged and, you know, destroyed. So it's I mean, yeah, it's a matter of balance, and I fully agree with your point that it's important to credit the authors of knowledge, and there are also already some, you know, copyright framework that, you know, exist, like Creative Commons, that, you know, gives the right to the knowledge creators, while at the same time promoting knowledge sharing. And I think, you know, what's we raise here, it's, I mean, it's it has, these are the issues that are raised when we started to talk about digital transformations, and which is amplified with the AI. Thank you.
Thank you very much. Ladies and gentlemen, I'm sure you have seen what we are in for. A lot of learning, but I'm happy that there are quite a number of applications which are coming up, and we have quite a number of experts in these areas, and that we can tap into their knowledge. But there are going to be challenges. Are there any areas where there are no challenges? There are challenges, and in this one we need to take care, but we need to get versed as to how we use this. Just Murugo, please clarify that I am not the one who had a problem with the weighing machine. I know I'm obese, but thank you very much. Ladies and gentlemen, please put your hands together for these wonderful panelists, and thank you very much for this session. Can we take a picture?
Thank you very much, Honorable Chief Justice. As the panel takes the photo, allow me to make an application under Certificate of Urgency that we forego the tea break and get into the final part of this program. So, Chief Justice, if you grant this application, we will get into the next part of the program. But do feel free whenever you need to grab a cup of coffee and bring it back with you. Thank you, Chief Justice. Are we in agreement?
How many minutes?
We are making a certificate very humbly to not have a break. Okay. All right, so the guidance that I've received, the ruling is back. May I beg your attention, please? The ruling is back, and we've been granted 5 minutes health break. Let's be back at exactly 10 minutes to 5. The next session will be 30 minutes, my lord, and then we will get to the closing. 10 minutes to 5. Thank you. Honorable Justice Moses Chinengo. Judge Chinengo has served in Zimbabwe as a judge of Superior Court, in Botswana, in Lesotho, in Namibia, and is doing incredible work with AJJF. Judge Chinengo will lead us through the session on the summit communique. Judge, allow me to welcome you.
I'm glad to say after the AI session and being told that we are all friends, whether we like it or not, but I'm happy I'm a friend to all of you. So, good afternoon again, friends, or is it evening? I think the task this is our last session, as I understand it. And so, having gathered for over 2 days and engaged in incisive deliberations, lively discussions, we must come up with some communique. As I sat there, I noticed the general consensus on challenges facing judiciaries in Africa and the tasks that lay ahead for the judiciaries as well as for our organization, the AJJF. This session is essentially to consider the communique that we will issue, and for that purpose, I will call upon C.J. Ottman, who will lead the discussion and approval by this body of the communique. In fact, it is a draft communique, and I think the final communique will be released in due course. So may I call upon C.J. Ottman to the podium, together with well, I think for the moment it will be just him leading us through the discussion of that discussion and adoption of the communique. I think there will be a PowerPoint presentation, but I think C.J. Ottman, you can come over and then we deal with this. Thank you.
Chief Justice Kome, dear colleagues, I've been co-opted by a very informal, geographically represented group that drafted this communique. But I think I don't have to be a fortune teller or a witch doctor when I see all of you that you don't want this summit to end. So the proposal, as AJJF chair has said, is to come up with a summit communique. But there are a number of things before I read out to you that we should have a common understanding. One is, please, we are not going into an editing exercise. Okay, we leave the editing, final editing, to the Secretariat and to the Justice who is unsworn. Okay, I think he promised us his fidelity to us. Okay, so let us not convert ourselves into a big drafting committee. Two is, it's a summit communique, not a list of activities. So broad measures, and most of the broad measures where the point of action, a lot of things can be done. So it has been drafted in a way that many things can fit in terms of initiatives and so on. So we didn't want, the drafters didn't want to come with a list of activities. The list of activities can be very elaborate, so we really don't have to tie ourselves into this. So long as we can whatever we conceive as activity could be read within some of the paragraphs. Thirdly, is that the way forward is that we hear comments, improvements, suggestions, and then the Secretariat will prepare a final draft, and they will share by email to all of us and give us time to indicate our final endorsement approval. So it's the same thing like what we call in corporate world a board resolution by circulation. Okay, I think so. If that is acceptable. So we are looking really mainly, as I'm told, by, if there are any omissions, any areas for emphasis, particular emphasis, so that we really reflect the very rich conversation that we have had last 2 days. So, the All Africa Judges and Jurists Summit 2024, having met in Nairobi, Kenya, from 17th of September to 18th of September 2024, expressing our deep appreciation to the judiciary of Kenya for hosting this summit and our resource partners for supporting the organization of this summit, recognizing that Articles 7 and 26 of the African Charter on Human and People's Rights guarantee everyone the right to a fair and public hearing by an independent and impartial tribunal in the determination of rights and obligations and of any other criminal charge. Conscious that Article 3, Sub-Article G and H of the Constitutive Act of the African Union make it an objective of the African Union to promote democratic principles and protect human rights and people's rights in accordance with the African Charter on Human and People's Rights and other relevant international human rights instruments. Recalling that in 2013, the African Union adopted the African Union Agenda 2063 as a blueprint on Africa's development goals, aspirations, and objectives, noting that judiciaries are a key stakeholder for the achievement of all the developmental aspirations set out under AU Agenda 2063, particularly Aspiration 3, on an Africa of good governance, democracy, respect for human rights, justice, and the rule of law, noting the progress that has been made by African judiciaries towards promoting good governance, democracy, human rights, justice, and rule of law, recognizing and appreciating the courage that has been demonstrated by African judiciaries to defend and enforce the rule of law under difficult socio-economic and political circumstances, including underfunding of judiciary, external interference with judicial independence, and persecution of judges as a retribution for their impartiality, aware that the undermining of judicial independence and integrity and the persecution of independent judges are also enabled and perpetrated by actors from within judiciaries, concerned about the challenges confronting constitutional democracy and the rule of law on the continent, including shrinking civil and democratic space, impunity, corruption, and general disinclination to conduct credible, free and fair election, committed to promoting access to justice, including on the repair of the ongoing harm and suffering of the African people as a result of historical injustices of slavery and colonialism, and reaffirming our dedication to promoting the rule of law as a tool for achieving development in Africa. We adopt this communique and through AJJF commit to. So there are 11 things that we commit to, and this is coming out of this deliberation for 2 days. Number one is to undertake measures to defend, protect, and promote the independence of judiciaries in Africa, including by offering solidarity to judges who face persecution for their impartiality and engaging stakeholders on the implementation of regional and international standards on the independence of judges and lawyers. Two, deepen collaboration with the African Union, human rights and rule of law bodies to promote the development of and implementation of African regional human rights and rule of law normative standards. 3, work towards the establishment of a judicial fund to protect judicial officers in distress or who are being persecuted for their impartiality and other reasons, in line with Resolution number 2 of the Manamotapa Plan of Action on addressing emerging threats to judicial independence in Africa of April 2016. 4, collaborate with the African Commission on Human and People's Rights to ensure that the development of the independent special mechanism on the protection of judges and lawyers is done with official consultation of and input from judiciaries and judicial officers in Africa. Number 5, strengthen collaboration with the mandate of the United Nations Special Rapporteur on the protection of the independence of judges and lawyers, including by undertaking collaborative measures to defend, protect, and promote the independence of judges in Africa. Number 6, undertake measures to strengthen the capacity of judges and the institutional capacity of judiciaries and judicial training networks in Africa to address contemporary challenges which affect timely delivery and access to justice, protection of human rights, and enforcement of the rule of law. 7, undertake measures to promote financial independence of the judiciaries in Africa, and also by recommending that financial allocation to the judiciary being ring-fenced by at least 3% of the country's GDP. And 8, provide legal and technical assistance to the African Union and other stakeholders on the implementation of African Union Resolution AU/December 847, 34th session, adopted in February 2023, on the need to claim reparations to address the ongoing suffering of the African people as a result of slavery and colonialism. Number 9, promote the decolonization and harmonization of African domestic legal system to embody and give expression to progressive African values. And number 9, to strengthen African judiciary's engagement with emerging technologies, including artificial intelligence, and leveraging on them to advance the rule of law and access to justice. Number 10, undertake measures to strengthen the role of judges in promoting civil space, including through the application of regional and international standards on freedom of expression, freedom of association, freedom of peaceful assembly, and the right to access to information. And number 11, undertake measures to promote electoral justice, including championing the development of a coherent Pan-African jurisprudence on the adjudication of electoral disputes. So the summit communique has 2 parts. The first part is the preambular one, and then the second one is the measures. So as I said, we can take a discussion. Any areas that you think need emphasis, or if there are any omissions, all of us agreeing that the Secretariat, our program director and his team will polish it up and then send it to us for endorsement. Thank you very much.
So I will invite comments and contributions, but I think I need to emphasize, as C.J. Ottman has said, the action plan, the actual activities will be undertaken as and when it is possible to do so. So that is why, regarding what we undertake to do, it is in general terms. So I see one hand. Yes, CJ.
So if I may possibly put it to the floor, that we might have a commitment as number 12 to undertake measures to enhance the judiciary's position as an equal pillar of the state.
Can you just repeat it so that we are clear, the proposal?
Thank you. To include a 12th commitment, but to fit it wherever you might see fit, to undertake measures to enhance the judiciary's position as an equal pillar of the state.
There's another contribution before we discuss this one. Well, if I may just comment quickly on that one, I don't know what your thoughts would be. We are, in terms of the separation of powers, the way I understand it, we are an equal arm of the state, isn't it? If we have to restate that, we might very well be kind of admitting that we are a lesser. We have challenges which we have identified, and by identifying those challenges and pursuing solutions to those challenges, we are actually enhancing and ensuring that our position as an equal, co-equal branch of the state is assured.
Well, with respect, I think all the conversations we've had in this group has been about the fact that, for example, we don't have financial independence. The legislature don't go to parliament to get their budget. Executive don't go to parliament to get their budget. We have to go and fight for it. There are all kinds of inequalities and a lack of respect for the judiciary as an equal and third arm of the state. And this, the proposal I have is to find ways of educating and enhancing that position.
And making it practical.
Yes.
Separation of powers is on paper in the constitutions, but practically, I mean, we are not even treated like we are treated like a department of one of the ministries in the executive.
Any other contribution? Yes. Yes, CJ.
Maybe, Chair, what you could do is to say.
I don't think that we need to make
Oh, just a minute. Sorry. Yes?
Sorry. This 12 recommendation is for me, like you said, we are a powerful power in the system. If either we put this idea on the preamble, but not as an action, accordingly. We don't need to put it as an action. We can note it in the preamble. For me, it's, even in the preamble, it's not necessary, because in all our constitution, we are en troisième pouvoir judiciaire, recognized. All what we are trying to put here is to tell them to consider the gap, to fill the gap, but not for me. We can't make a communique to undertake to invite the executive and the parliament to consider it as a power.
CJ Mtunga.
I actually like that proposal, particularly when this arm, we call it an arm, it's not even an arm, it's a stamp of something that isn't there. And she's very general. She says measures, and these measures might include how we get public following for, for public to basically reach out to public to get protection, and also to, because you see the judiciary is always said by parliament and the executive, who elected you, all right? So one of the critical measures that, in my view, we found in Kenya is first, like in the court users committees, that's one way of involving the people. The AJS, okay, which is the integration of formal and informal justice system, is going to give us a public following, okay? And I thought those are the measures that we could use to fight this notion by parliament and executive that they own the resources, because it's forced, and it's because that is their position. So we've got to fight it through judicial politics of some sort. And I think those practices that our colleague is talking about, it will be for us to find out which ones are, workable.
Yeah, well, it seems to me that the general drift is that we need to state something along these lines to ensure that while we are, of course, a pillar of the state, one of the three pillars, but there are measures which can be recommended, adopted, to ensure that indeed a third pillar, which is not seen as one of the underlings of the other pillars of state. So I would think that the drafting committee, the secretariat, you would properly word. It's one of the areas, of course. My understanding is one of the areas in which AJF would undertake studies, make recommendations, assist judiciaries in ensuring that they can become an effective pillar of the state, especially in regard to allocation of resources. So I think that one will be in. Any other comment? I had a comment on the proposal. Yes. Yes, Ms. Kubaba.
Yes, thank you, Chair. When I was listening to the suggestion which came from the Chief Justice of Seychelles, I thought perhaps you could try and marry it with paragraph 7, where we talk about undertaking measures to promote financial independence of judiciaries. Perhaps the drafting committee could find a way of merging the two, the separate arm of the state together with the empowerment of financial independence to judiciaries. Maybe that way what is coming across would then be affected. I wasn't quite sure. There's something that the Honorable Chief Justice read out also under paragraph 7, but what is not reflected on the screen before us. If they could move to paragraph 7 on the screen.
On the screen, it is not there, but I can read out. You can read out the proposed amendment, and that was the point I also wanted to come back to. But you can read.
Thank you.
It reads, by recommending. Yes.
The revised paragraph 7 will include two elements. We leave it to the drafters. The message is that measures to promote financial independence of the judiciaries in Africa, including measures that go towards the financial allocation to the judiciary of financing being ring-fenced at least 3% of the GDP. That was the other part of it. Those two ideas that were there. But there will be a rewording, I think, so that it flows. It flows. So this is probably one of the measures, but it's a policy measure. It's a high-level policy measure. If it's not very actionable, like like your annual budget and so on. So it's kind of more visionary in terms of where we are going.
So I take it that when the drafting committee is looking at paragraph 7, you might as well see how you marry it with the proposed paragraph 12, because it's all about financial independence of the judiciary. But the only point I wanted to, you may help me with the answer. The only point I wanted to raise in regard to the 3% of GDP is whether it is the 3%, at least. Yes, no, that's all right. But I'm just trying to think of whether in other countries it could not be 5%, in other countries at least, okay, if we use the word at least. But I was just wondering whether we need to be specific as to the percentage, or simply say an appropriate percentage of the GDP, because the specific might be country to country. That is the only point I wished to raise. CJ.
Thank you. On that one, part of my presentation was that anything you need needs to be made extremely clear. Otherwise, you give them a chance of not implementing. So a percentage, I'm not talking about 3% necessarily, but a percentage should go into the report, into the communiqué. As a starting, in any case, you are saying at least this. Other countries can have even more. I came a little late. I didn't follow all the paragraphs. Is there one seeking for the judiciary to be given a seat at AU? Because the politicians meet, decide matters of state which are involving resources of countries without the judiciary being factored in at all. Is there, there should be one to fight and get a seat at the AU where the judiciaries can express their views and the frustrations about what is happening. I don't know.
No, thank you. I think before we come to the latter point, I think it's generally agreed to cater for country differences. That insofar as the recommendation on the percentage. I don't know, I'm not an economist, but will it be a percentage of the GDP? Is it a percentage? But I think the recommendation as it now is 3% of GDP. But I think we are generally agreed that we substitute the 3% by the wording appropriate percentage of the GDP, so that it may be 3%, 5% country to country. Yes.
In terms of at least, but when you say appropriate, so supposing a state thinks 0.5% is appropriate.
No, but you see, there's a difference between a recommendation to action and an actual recommendation. Assuming AJJF were to come to discuss or to assist in that respect in Uganda, they would have to say in Uganda 5%. You see what I'm saying? Because this is a call to action by the organization. You recommend an appropriate, I think the essential point as far as I'm concerned is that it must be a percentage of the GDP. And if that is acceptable, then from country to country it could be. But yes. Yes.
The idea of having a minimum bargaining position is not even unique to the judiciary or to the justice sector. The heads of state themselves, the African heads of state, use it
for agriculture and the agriculture sector and other sectors at the African Union level. They do put that minimum limit. So what the minimum limit does is to give you a bargaining position, you see. But if you're saying appropriate, what's appropriate? The Museveni or whoever will tell you, this is what I think is appropriate. But you just need a minimum level. In any case, what is happening now is far below 1%. 3% is much higher than what is happening, even with the best judiciaries. South Africa, we have been told, is 2%. Uganda is 2%. Nigeria is 2%. Is that what we heard, I think? Yes. So 3 has even raised the bar. Mostly is 0.3 and 0.5. So I think 3 is really, it has raised the bar. It's good. I think I would suggest that we have a minimum.
Yes, before I call in CJ Altman,
Yes, I think the point has been made better by Martin, but it is 3% of the national budget, the annual national budget.
Yeah. Not GDP.
Not GDP. Yeah.
But there must be a figure, the minimum figure.
An advocacy figure.
Yeah.
In the next summit, we get it to 5, but for now we start at 3.
Right. Any addition? No, in that case, then I think it will pass and marry it with the other, the proposed. Yes. Sorry. Oh, yeah. I hadn't called on you.
I think what I wanted to say has been preempted by Justice Reneora. I used to work for SADC for 8 years, and these issues of percentages are also even applicable in the regional economic communities. For example, if you go to SADC, percentage of only 8th, and the AU, they agreed in Abuja, only 8th, and so I would say we provide the specific figure, not appropriate, because the standard, the practice is they provide a specific minimum. And then again to echo Justice Reneola, it's of the annual budget, not the GDP.
Yes.
I think that should be made very clear. Thanks.
I think that, yes. Madam?
Thank you so much. I'm just wondering whether we have captured one issue that is very burning to me about how, and that I gained from the presentations, about the judiciary representing its own report and status vis-a-vis finance to Parliament without passing through the executive. I don't know if we have captured that somewhere. We should have our own voice and not go through executive. Number 7.
Yeah. Any thoughts on that proposal? My understanding is that it might be a provision in law in different countries how you present your budget. In some countries, it is that you probably present, the Minister of Finance comes up with the national budget and presents it to Parliament. In other countries, like I understand from Kenya, the provision is that you should take your budget straight to Parliament. So I don't know how, maybe the drafting committee can look to see how it can be accommodated. Yes? Yes.
Under 7. Yeah, because 7 is talking about financial, judicial financial independence.
Mm-hmm.
So that involves the means by which money is appropriated and allocated to the judiciary. Yes. So the idea of what she's saying is a detail of how to achieve number 7.
All right. Now, there is another point raised. It's still on the budget.
Not on the budget.
Yes. Another point before we forget about Chief Justice Maraga suggested, said that we must say something about a seat for judiciaries at the AU. The only point I wish to make before we get into a discussion is the communique is dealing with what generally we discussed at this conference. If we can subsume it under one particular kind of discussion we had, then it emerges from this conference. I don't know, would we?
Could easily come under number 7.
Judicial dialogues. We have talked about judicial dialogues in Africa, and whatever we dialogue must find room at the African Union for adoption, and we must also find a voice at the African Union to represent our dialogues, our challenges, and to work together with them in these agendas we were talking about. So I think it should find somewhere among the discussions we were having. Because we are not talking just to ourselves, we must be able to talk to the African Union.
Yes, any other contribution? Is it on the same point or? No. All right, but I think in terms of the action program for AJJF and its associates, the point is that is one of the recommendations that it would look at, isn't it? So I think the drafting committee can look to see where we can insert, including recommendations regarding a seat of judiciaries at the AU. I think if we look through these clauses, we might include that as part of the action plan. Yeah. Yes. Is there any other contribution on this point about the seat of the judiciary at the AU? But I think we can look to see where it can be inserted as part of a possible action recommendation by the AJJF. And I would be quite happy to leave it to the drafting committee to see where they would insert it. The principle is accepted. And I think the justification for it has been articulated. Yeah. Okay. Now, I think of additional action points, I think that is the last I had. Now, Judge CJ.
Nothing important, really. But I thought that the drafting committee might want to sit down and carefully sequence the ideas, because they seem to be thrown around all over. Key and leading paragraphs should be at the top. The others that are, if you look at point number 6, should probably have come earlier, and so on and so forth. So can the drafting committee try as much as possible to make the ideology flow? That's all.
Anyway, thank you. I think that is the task of the drafting committee, admittedly. So it's up to the drafting committee. Please make sure that things are sequential. Everything makes it logical reading. I think that is a good contribution. Justice Ottoman, anything else? So generally, as it was said, or as I say it now, the communication is generally adopted. The drafting committee will finalize it, ensure that ideas flow, paragraphs which are together flow, and then they will distribute the communique in due course. Thank you very much for the contribution.
Thank you very much, Honorable Judge. Thank you very much, Chief Justice. And thank you to all of you. We look forward to seeing the final iteration of the communique. As we draw to the close of this summit, I'm sure all of us are feeling very refreshed, in terms of ideas, and hopeful have a voice and will find anchor in our governance processes at a Pan-African level. Allow me to welcome Honorable Chief Justice Emeritus to close the summit for us. Chief Justice, thank you.
Is it possible to get some liquor so that I pour libations? Distinguished participants, I observe all protocol as detailed by Justice Isaac Lenaola yesterday. Today we come to the close of this remarkable gathering. I stand before you deeply impressed by the profound sense of dedication we have witnessed over the last 2 days. We embarked on this journey with a shared vision to pivot the judiciaries of Africa towards a transformative role in shaping the future of our continent, united by the determination to build a stronger, more just and prosperous Africa. As we conclude, I urge each of us to take the lessons, the ideas, and strategies from this summit back to our respective jurisdictions. Work does not end here. Rather, this is the beginning of a renewed commitment to transform our judiciaries and, through them, the future of Africa. We must build on the networks established here, collaborate across borders, and continue the conversations that will drive the change we seek. In closing, I extend my deepest gratitude to our host, the Judiciary of Kenya, for their support. To the organizers, speakers, and participants, thank you for your tireless contributions to making this summit a success. Your passion and expertise have enriched us all. Together, let's strive to uphold the rule of law, safeguard human rights, and ensure justice for all. Africa's future depends on it, and I have every confidence that with our combined efforts, we will achieve the vision of a continent that is not only a global powerhouse, but also a beacon of justice, equality, and dignity. Thank you all, and I wish you all safe travels as you return to your countries. Let this summit mark the beginning of a new chapter in Africa's constitutional, legal, and judicial journey. Asanteni sana. May our ancestors of Africa protect you, and may God bless Africa. Thank you.
Thank you very much, Chief Justice. Indeed, it has been a wonderful, wonderful summit. And to sum it up, they say that we all leave as we came. So as we welcomed, so shall we be bid goodbye by the Secretary General of AJJF, Mr. Martin Masiga.
Now, firstly, allow me to just correct a misunderstanding. I have got 4 people coming to congratulate me for having held our first meeting. Because we are calling it the inaugural All Africa. No, no, no. AJJF has been holding meetings before on different subjects for different countries and regions. So when we talk, we say it's all Africa. What we are talking about is the first meeting where we intended to have the complete representation of this continent. North, South, English, Portuguese, French. That's what we mean. This is the first one. Otherwise, we have been working, and we are going to continue working as we have. Now, I hope that is clear. Now, secondly, I've been requested to make an announcement that the JIG, the Judicial Integrity Group, to which Justice Twomey belongs, I think Justice Dingake too? No. Okay. So that group made a request to the UN to declare 11th January the Day of Judicial Independence. The annual Judicial Independence Day. So, yes. So, Guterres has just accepted, and 11th January next year will be the Day of Judicial Independence throughout the world, and judges will be expected to be marching on the streets of your cities. So please join in the march. Thirdly, I would like to request us to stand for a minute of silence in honor of Professor Michel Lohansungule, who was a member of AJJF, a renowned human rights professor at the University of Pretoria, Lund, and other universities. He died about 5 days ago. Please, let's observe a minute of silence in his honor. May his soul rest in peace. I would like to thank our host, the Chief Justice of Kenya, and the judiciary of Kenya. This journey started with the judiciary and with her, and we are ending it with her and with the judiciary. Thank you very much, Chief Justice. I would like to thank the teams that have worked on to put this meeting together. I have been watching, following. Sometimes I wasn't with you, but I know just how much. Please do not make a mistake at all to imagine that I do not know the strain, the sacrifices, sometimes even the frustrations that you have gone through. I have seen, I have followed. Thank you very much. I will ask you to stand up. All the Secretariat of AJJF, can you stand up, please, for recognition? And all that work with the KJA, the Kenya Judiciary Academy, please, will you stand up for recognition? Thank you very much, Wako. Thank you very much, my brother there, Duncan, and in the corner there. So to our sponsors, I thanked you the other day, and I thank you again. If you sow a seed and do not water it, and then the rain also does not fall onto it, what happens to it? It dries up. We have started this journey, the All Africa journey with you. Please be there next year with us, so that we make sure that it grows up, it matures. We need to harvest. Africa needs to harvest from it. Thank you very much. I would like to now thank every one of us that has come here for the time you have spent here, for the sacrifices that you have made to be here. Thank you very much. Safe journey when you travel back home.
Thank you very, very much. Chief Justice, we've received a very special request from the Secretariat. They would like to make very short announcement, and then we will close with the national anthem and dismiss. Justice? And Elizabeth, could we have Elizabeth here, please?
Thank you, Ross. The following honorable judges, may you please remain behind as others leave for a short meeting with Justice Lenaola and myself. So that will be Justice Moses Chinengo, Justice Mary Dube, Justice Kitingake, Justice Charles Mukandawere, Justice Charles Wungwe, Justice Antonia Kuvawa, Justice Christopher Dube Banda, Justice Amadi Ba, Justice Francis Tuyot, if you are here, Justice Kosi Bo, Justice Doris Mwiriki, Justice Lombe Piri, Chief Justice Emeritus Andrew Nyirenda, Madam Justice Marceline Afuda. Then lastly, Elizabeth, there's a short announcement to make regarding logistics as we move from here.
Good evening, my lord, my ladies. The checkout time for HGF-sponsored delegate is 10 a.m., and arrangements have been made for delegates whose flight is later than 10 a.m. Then transportation to the airport shall be available at the reception. Pick-up time is 4 hours before the flight. Thank you, everyone.
Yes, we are enjoying the fruits of our superhighway. But I'm sure the Secretariat will guide each one of in a more personalized manner. So I can assure you that we will get you to the airport in good time and not keep you there unnecessarily long. So please be assured. May I request that we now be upstanding for the closing prayer and wish all of you safe passage. The national anthem. The one with the sound. We can sing it? E Mungu nguvu yetu,
ilete baraka kwetu, haki iwe ngao na mlinzi, na tukae na undugu, amani na uhuru, raha tupate na ustawi.
Thank you very much. With your permission, Chief Justices, we can all take our leave.